Okay. Heard Mr. What is your name? Heard Mr. A. Ganguly, learned counsel for the petitioner, who submits that there is another connected CRPIO, that is CRPIO number 140 of 2024, which was also heard in part by this court. And he prays that same may be tagged with the instant civil revision petition, and both the matters may be heard together. The prayer is allowed. The registry is directed to tag the CRPIO number 140/24 along with this civil revision petition and list it for hearing on 23rd January as part heard matter.
Okay.
Yes, Your Lordship. Lordship, my senior is on leave. Kindly pass over the matter to kindly.
Yeah, after some time.
Wait, this is your lordships. Lordship, this is a statutory appeal under section 30 and MFA lordship from EC case. So the substantial question of law lordship I have formulated at page 7 lordship.
What is the matter?
Lordship, this is a injury case lordship and in that injury case, the judgment of 3,53,606 was passed. We are saying that the disability does not reduce his earning capacity in every employment. And to that effect, our High Court has also passed judgment, lordship. So our contention is that though the learned commissioner has assessed the compensation under section 41C, it ought to have been under section 41D. And for that lordship, the maximum period that a person gets the compensation is for 5 years. But that has to be, the disability should be till that point. So that, but the maximum period is that lordship. And the second is lordship that the interest is granted from the date of accident. But this is also settled law lordship that in injury case, in death case, yes, from the date of accident. But in injury case, from the date of adjudication of the. So those are our two substantial question of law.
But in the injury case, it has to be from the date of
Adjudication from
the
the
law
date.
is settled.
Yes.
Then
Settlements.
how it is substantial? It is only question of application of the law.
So lordship, that application settlements in some cases, they are giving it from the date of claim petition. But from the date of accident, in injury case, it won't be.
Third is R.D. Majumdar, learned counsel for the appellant. This appeal under section 30 of the Employees Compensation Act from 2023 has been preferred by the appellant, namely Oriental Insurance Company Limited, impugning the judgment and award dated 1/8/2023 passed by learned commissioner for the Employees Compensation cum Assistant Labor Commissioner Nagaon in case number NEC within bracket WC bracket close 37/2012. After hearing learned counsel for the petitioner, as well as after going through the materials on records, following substantial question of law is formulated in this case. Whether quote substantial question from page 7, 1 and 2.
And any other at the time of hearing lordship.
No. This appeal is admitted for hearing. Issue notice to the respondents. The petitioner, the appellant shall take steps for issuance of notice on the respondents by registered post with AD as well as by usual mode within 3 days from the date of, within 7 days from the date of this order, returnable on 25th calendar. Returnable on 24th January 2025.
I have a stay petition also, Lordship. I 3427, oh, sorry. No, Lordship, I do not have a stay petition. I'll apply.
When you start proceed, the person also there was a condemnation of the I which was the disposal of it. Now the MFA has been come up also. Thing is that was my side doesn't have a copy of the MFA also. The matter has come up for admission today. So I just think
The delay has been condoned.
it has been confirmed that the MFA has come up, but I doesn't have a copy of the MFA. So that is the thing.
Okay, what is the appeal against?
So order passed by the tribunal also of railway tribunal. If I am not wrong, because I.
Then we'll admit the appeal, we'll
Yes,
call for the records and ask
Ma'am.
him to furnish.
yes.
So I have to see what is there in the report.
We'll take steps, my lord, so we'll submit copy of the demo. Appeal may be admitted.
Others lawsuit may, said what is not lawsuit things to. Lawsuit, what lawsuit things to lawsuit?
No, but you have to furnish copies before it is.
At the time of filing the appeal, we serve the copy of the
No,
memo.
there will have it. I am
There's
not
the
saying that he has
procedure.
not served, but thing is I should have the copy.
My lord, that is the procedure we are following. At the time of filing, we serve the notice.
I am not,
Because
I am
this
not,
kind of-
I'm not doubting that.
Uh,
Yeah.
There is the procedure we are following, my lord. At the time of filing itself, we used to serve notice. Anyway, my lord, if your lordship pleases, my lord, it may be admitted,
Heard
we'll serve notice.
Mr. J. Mullah, learned counsel for the appellant, also heard Mr. C.K.S. Burwa, learned counsel for respondent number,
One respondent also. So
respondent, this sole respondent. This appeal has been filed under section 23 of the Railway Claims Tribunal Act from 1987 by the appellant impugning the judgment dated 30/9/2022 passed by the Railway Claims Tribunal Guwahati in original claim application number 116/2018. Stop. I have perused the grounds taken in the memo of appeal by the appellant. The appeal is admitted. Let the records of original claim application number 116/2018 be called for from the Railway Claims Tribunal, Guwahati. The appellant is directed to furnish a copy of memo of appeal to the learned counsel for the respondent during the course of the day. Release this matter after receipt of the records from the trial court. What is this?
Condemnation petition earlier disposed of.
You are for the respondent. Who is for the applicant?
Dear Polita.
None has appeared for the applicant on call. Mr. What is your name?
Pick it up.
Mr. P.K. Datta. You are
What is full respondent?
appearing for the sole respondent is present. Let this matter be listed after vacation.
Okay, appellant, my. Appellant. This is the missionary's first appeal now for it.
No, but delay has been condoned. Okay, okay. Then instead of applicant, appellant.
The date case and the substantial question at page 9.
Yes. What is the matter?
The compensation in a date case, compensation was counted from the date of re-examination of witness.
Re-examination of,
Witness.
okay.
The compensation was
Anything,
You have the memo, Sutin Lakshit,
but notice is yet to be issued. You
that's why.
we
I saw
heard Mr.
you.
U. Datta, learned counsel for the appellant, also heard Ms. R.D. Majumdar appearing for
Respondent number
respondent number 2. This appeal under section 30 of the Employees Compensation Act, 2023 has been preferred by the appellant, impugning the judgment and order dated 30/9/2022 passed by the Commissioner, Employees Compensation, Guwahati in WC case number 58/2013. After hearing learned counsel for the appellant as well as considering the materials on record, following substantial questions of law are framed. Quote from page 9, number 1 and 2. This appeal is admitted for hearing. Issue notice to the respondents. Since Ms. R.D. Majumdar has already appeared for respondent number 2, no formal notice need to be issued to respondent number 2. As regards respondent number 1 and 3, the petitioner shall take steps for issuance of notice upon the said respondents by registered post with AD, as well as by usual note within 7 days from the date of this order, returnable on 27th of January 2025. Let also the record of WC case number 58/2013 be called for from the Commissioner, Employees Compensation, Guwahati, registry to issue requisition. List this case accordingly. You furnish a copy of memo of appeal to the other side.
There is no respondent number 3 is not there. 1 and 2.
Please there.
No, Lordship,
In our-
only 2. DK agents.
1 is BK agency and 2 is
They have
superintendent.
not made the driver a partner.
Oh, yes. Instead of 1 and 3, and then 2 steps for respondent number 1. Okay.
Higher.
Lordship, In item number 3, maybe the LCR is not called. On the answer.
Item number 3, LCR कौन कौन नहीं. We'll call
Highly obliged.
item number 3, call for the trial court records.
It's Major Lordship. My lord, this is an appeal lordship filed by the insurance company under Employees Compensation Act lordship. And the substantial question of law lordship will find at page 6A lordship. Your lordship, the driver had no hazardous, carrying hazardous endorsement for carrying hazardous goods lordship. So there is a violation of terms and condition of the policy, number 2. And firstly, lordship, this was, he was a driver and his monthly income was accepted as 17,261, which has got no evidence. There is no evidence to that extent. And thirdly, lordship, the factor accepted lordship, that is wrong factor has been accepted.
Where is the substantial question of
At
law?
page 6A, lordship will find. Factor is also accepted wrongly, lordship.
Third, Miss M. Chaudhary, learned counsel for the appellant. This appeal under section 30 of the Employees Compensation Act, 1923, has been preferred by the appellant insurance company, impugning the judgment and order dated 28/12/2022 passed by learned Commissioner Employees Compensation Act 2023 Golaghat in EC case number 7/2020. After hearing learned counsel for the appellant, as well as after going through the materials on record, following substantial questions of law are formulated in this appeal. Dash. Quote from page 6A, within bracket, wrong within red, diase. 6A. 6A. This appeal is admitted. Of issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by registered post daily, as well as by usual mode, within 7 days from the date of this order, returnable on 29th of January, list accordingly.
The petition for stay, lordship. This is 2371 of 2024.
Stay. Is there any execution case filed?
I have not yet, I have no instruction regarding execution, lordship.
Then we'll issue notice only.
And lordship may hear at their presence, that may be considered, lordship. Must oblige, lordship.
My lord, I'm giving a chart, my lord. That will, my lord. Your lordship will just take it up. My lord, here's what happened, my lord, in 1960, my lord. That deed was executed with the appellate petitioner, my lord. For a period of 25 years for, my lord, setting up a manufacturing plant for production of gases. Then, my lord, that 85 lease was expired, but they were allowed to continue. In 2008, this lease was executed, but it was said that, my lord, that another lease will be done because it would be registered. Then, in 2009, my lord, another lease was executed for 25 years, and that was given effect from same date, 1/7/2008. Terms and conditions are almost same, my lord. Then, my lord,
Lease
issued a transition
lease
notice.
of
Hello?
lease of land.
land.
Okay.
Land. We have established the manufacturing plant, my lord. and we are positioned against this, my lord.
Yes.
Then, my lord, in 2013, my lord, defendant issued us termination notice, my lord.
Termination
No,
notice.
termination notice, my lord. Petitioner did not vacate, my lord. Then, my lord, they have issued a notice under Public Nuisance Eviction of Unauthorized Act again on 21/8/15, my lord, the last act. Your lordship. Then plaintiff agreed, my lord, that he filed a miscellaneous appeal, my lord. In miscellaneous appeal, my lord, interim order was passed by the court, my lord. That's this. Then, my lord, again, another agreement was executed between them, my lord. They allowed to continue, my lord, the petitioner, and that is why the miscellaneous appeal was withdrawn. And based on the agreement, my lord, everything is done. Then, my lord, again, my lord, defendants issued a eviction notice in 25/4/23, Annexure 8, my lord, that your lord got. Wonderful. So, in that, my lord, they have referred to a lease dated 24/5/2009. Eviction notice was issued, but no action was taken on that basis, my lord. Then subsequently, my lord, again another notice was issued on 10/10/23, Annexure 9. No plenty. Then defendant, there also they have referred to a lease dated 2009. Then defendant issued eviction notice 20 under Public Nuisance Eviction Act, my lord. The plaintiff again, my lord, filed a miscellaneous appeal, my lord, to the additional district judge, my lord. And additional district judge, my lord, passed an interim order. Then, my lord, this notice was again revoked, my lord, by a speaking order on 15/2/24, my lord. Your lordship got to do. This Annexure 12, my lord. Speaking order at 15.
Which notice was revoked? 10/10/23 notice.
My
was-
lord, that was evidence. Yes. So miscellaneous appeal was withdrawn, my lord.
Okay.
Now, my lord, now they have issued this 10/7/24 notice. That is the subject matter, my lord. If your lordship come, my lord, to this. Page 97 of the IA, my lord.
Putul, I agree. Yes.
My lord, you are hereby notified that terms of the lease dated 21/6/2008. My lord, that has already been superseded. That lease by 2009. Earlier, two notices were issued under 2009. You are required to vacate the plot of land, whereas lease dated so and so, a land measuring so and so has been leased out to Kamrup Industrial Gases, so and so. It happened from 1/7/2008. Whereas, as per clause 18 of the lease deed, dated so and so, effective from 1/7/2008, the lessee has to hand over the lease if lessor requires a plot of land for his own use for expiry of the lease tenure, that is 25 years, providing a 6-month notice is given. Now, whereas a plot of land is now required by the lessor for the purpose of construction of so and so. Whereas, as per clause 18, the deed did 6-month notice to be provided, further the land was leased out. for specific
When
purpose.
this 6 month will expire?
Hello?
When this 6 month will expire?
10
Notice
January.
10 January.
Now I'm coming over. So now, my lord, this is there. Your losses will now refer to the lease deed dated 2008. 2008 lease deed has been superseded by 2009, my lord. My lord, your losses will see 2009 lease deed is at page 53. When this lease deed has been executed, 2008 lease deed has nothing to do, my lord. Because earlier two notices were issued under 2009 lease. This is one of the ground, my lord. Second main ground is the, my lord, clause
No,
18.
we are issuing notice.
Oh, my lord, yeah, I'm coming, my lord. If you also see, that why I'm saying so, that
Because still there is time.
time, but clause 16, my lord, your lordship may see. But they, where it, my lord. If your lordship see page 18,
No,
page 15.
No, Mr. Sahiwala, what
Yes.
I am on, before 10th of January, they will not do anything. We'll fix a date before 10th January. Let them say, let them,
That is, my lord, during vacation period, my lord, notice, my lord, is hard, my lord, that is the difficulty, my lord. That is why I'm saying, at least status quo may be maintained till then, my lord, that nothing will happen to that. Because if your lordship see the clause,
no, 10th January is, even after reopening, there is sufficient
yeah, my
time.
lord, the only thing, if your lordship see clause 16, my lord, then your lordship will be satisfied. Clause 16, my lord, whether there is a right to issue the notice, my lord.
No, maybe, but there is no such urgency to grant stay without issuing notice, because the period of notice will expire only on 10th of January. We'll fix it on 3rd of January. Third, Mr. G. and Sahiwala, Lanet, counsel for the, Lanet senior counsel for the
Okay.
appellant, assisted by Mr. Yes, what is your name? H.K. Sharma, Lanet counsel for the appellant. This appeal
Okay, thank you. No, sir.
This first appeal against order has been preferred by the appellant, impugning the order dated 29/11/2024, passed by Lanet Civil Justice Senior Division Number 3, Kamrup Metro in Guwahati, in Ms. J case number 1113/2024. In title suit number 631/2024, whereby it refused to grant temporary injunction restraining the respondent from taking any cohesive action on dispossessing the appellant from the scheduled plot of land in pursuant to the eviction notice issued on 10/7/2024. I have perused the grounds assailed by the appellant in the memo of appeal. The appeal is admitted. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by registered post with AD, as well as by usual mode, within 3 days from the date of this order, returnable on 3rd of January 2025. In IA, this interlocutory application has been registered on filing of an application under Order 39, Rule 1 and 2 of the Code of Civil Procedure, read with Section 151 of the CPC for restraining the opposite party from dispossessing the applicant from the scheduled land in pursuant to the eviction notice dated 10/7/2024. Issue notice to the opposite parties. The applicant shall take steps for issuance of notice upon the opposite party by registered post with AD, as well as by usual mode within 3 days from the date of this order, returnable on 3rd of January. Though learned senior counsel prayed for grant of an ad interim stay. However, it appears that the impugned notice is
Expire on 9/1.
will expire on 9/1. Hence, this court deems it fit to consider the pray for stay only after service of notice on the opposite parties. List this matter on 3rd of January.
But in case the service is not affected, my lord, that is going to be done. My lord.
Then we will see on that day. We
Well,
can,
that may be observed, my lord.
no, no such observation. You may take steps
Yes,
through
I will still take step.
Dusty mode if you,
Yes, yes.
that,
Because
that I, that,
What happened here?
that I can allow if
Hello?
you, if you want to take steps by, through Dusty mode. In addition, on prayer of learned counsel, senior counsel for the petitioner is allowed to take steps additionally through Dusty mode on the opposite parties. In the I.
I think the lordship has heard this matter. It has been part heard. In the meantime, we came to know that this matter has been moved before this court. And accordingly, I think some time was paid for this matter. Time was
Yes,
well
when I heard it, none appeared for responding.
Yes. Subsequently, our client has contacted Mr. Talukar and accordingly, my lord, we have been informed to appear in this case.
Today, both of you are ready.
Problem is that what I found, there are two issues in this matter. Subject to what my learned friend says. So their whole case which I found is a point of jurisdiction. That at one point of time, a transfer petition was filed before the Supreme Court. Once you file a transfer petition from the Supreme Court, that means you have given up the point of jurisdiction. So it's a question. That's what they said. So it's a barred by rejudicata. So you cannot raise that point subsequent. In the High Court also, the revision petition was.
Now, what happened to the transfer petition?
So transfer petition withdrawn. So now it has been withdrawn. Now, my lord, there is also criminal petition. There are a number of petition was filed here. But after that, whether my right will continue to take that point before the learned court below or not. The point of jurisdiction. They are saying that your right has been closed because you never raised this point. Either in the Supreme Court, no liberty has been taken from Supreme Court in connection with that case. You should have taken a liberty from the Supreme Court.
Liberty for?
Liberty to take the point of jurisdiction. Because once you have given up and you have gone before the Supreme Court and you have sought for transfer because on the point of jurisdiction and the Supreme Court did not interfere in and dismissed. Now, what is the law, my lord? Once it is dismissed,
No, we'll
simply
hear,
sit down.
we'll
Now-
hear.
That's a point which your lordship has been very thorough. It takes a lot of time. Because I have got few judgment on what do you mean by merger? What do you mean by doctrine of merger? Whether, so this will take time. So only a prayer has been made,
Today we have time. You are ready.
but only the problem is after 2 o'clock, they will be difficult for me, my lord, because I have to move from here.
You are reluctant.
That's the only problem. Today, at least today. In the meantime, one request is being made. My lord, if the first point, your lordship decide on the first point, which they have raised it. And if your lordship says that no, that they have got a jurisdiction, then your lordship has to call for the records from the learned court below. Because I have seen this was evidence.
Records are,
Records are.
Records are there, I think.
Then is of course, then fine, because I have seen the evidence also, where in the evidence it clearly spelled out, only in respect of Guwahati. So only what I pray, my lord, if it is not inconvenient to my learned friend and your lordship, by the way, your lordship can take up this matter on Monday also, there is no problem from there.
Mm,
Because it's inconvenient.
Not Monday. If it is adjourned today, it has to go after vacation.
At, I think 2 o'clock, subject to my learned.
But he has to start off the case.
Lordship, I'll give a brief summary, Lordship, I'll do it in brief, Lordship.
We'll
I,
fix.
what I suggest that if it is not inconvenient, let it be partnered and let it remain, that is an on closure.
It is still a part-heard matter.
Yes. Immediately after reopening of the matter,
Let it be on first, in the first week.
not third, fourth, it will be convenient.
You choose a date.
Lordship. Although there was some urgency, Lordship, however, Lordship. Was the matter to be heard in the beginning of January, then Lordship, as soon as. Sixth in that case.
Yes, fine, so.
Third, Ms. P. Burwa, learned counsel for the petitioner. Also at Mr. D. Das, learned senior counsel, assisted by Mr. D. Talukdar, learned counsel for respondent number 2, as well as Mr. K. Butcher, learned additional public prosecutor. On request of Mr. D. Das, learned senior counsel appearing for respondent, this matter is adjourned to 6th of January, till 6th of January as a part-heard matter. The prayer for adjournment was conceded to by the,
She reluctantly
Right.
can consider
Why
Lordship.
not use that word. consider.
I'm not,
Problem for-
delete that.
Otherwise, I was ready, Lordship.
Okay. No, I'm not mentioning anything.
Yes.
Let this matter be listed on 6th of January as part-heard matter.
Yes.
Is an appeal by claimant for enhancement.
Or enhancement,
Enhancement.
Mr.
A Bhattacharya.
A. Bhattacharya, learned counsel for the appellant. This appeal under section 173 of MV Act, Motor Vehicles Act, 1988 has been referred by the appellants / claimants praying for enhancement of the award passed by the impugned judgment and order dated 10/9/2024 in MEC case number 134/2018 by learned member Motor Accident Claims Tribunal number 2, Kamrup Metro. Stop. This appeal is admitted. Let the records of MEC case number 134/2018 be called for from the learned tribunal. Let also notices be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
That's okay.
But in this case, so far service report is concerned, I think it is complete.
None has appeared for
This is so far number one is concerned is through paper publication. None has appeared yet.
And number, who is,
Is the owner of the vehicle.
trial court records have not been received.
Record will be necessary. Two is served. Respondent two is served.
Which is the office note?
Vishnu dated 37/2018.
So there is an order regarding due service of notice.
Yes, yes. That is said, where is the postal journal?
Okay,
It
okay.
appears that notice was issued on so and so.
Out Mr. S. Dutta, Learned Senior Counsel, assisted by Mr. S. Dutta, Learned Counsel for the appellant. In this case, it appears that service of notice on both the respondents in this case, it appears that notices issued to both the respondent have been duly served. Stop. However, the registry has not yet received the records of the trial court. Stop. Issue reminder for the same. Let this matter be listed again after receipt of the trial court report records.
Be allowed to file a substantial question of laws. It appears we did not file it.
Oh. That was a statutory requirement.
Yes, under section 30, it's a must.
You have not filed.
Anytime subject to your lordship's consent, we can file it.
What section 30 says?
30 is
Employees,
Employees Compensation Act
Employees
1923,
Compensation Act.
section 30. Provision of appeal. Lordship got it.
Yes.
An appeal shall lie to the High Court from the following orders of Commissioner, namely, an order awarding as compensation a lump sum whether by US so and an order refusing to allow redemption of half monthly payment, an order providing for the distribution of compensation among the dependents of a deceased, an order allowing or disallowing any claim for the amount of an indemnity under provision of section so and so, so and so, an order refusing to register a memorandum of agreement, provided that, this is important, provided that no appeal shall lie against any order unless a substantial question of law is involved in the appeal. In the case of an order other than an order such as is referred to in clause B, unless the amount in dispute in the appeal is not less than so and so, the central government may by notification. No, we are not concerned with that. Now, in any case, my lord, a substantial question of law is a precondition.
But it is not like section 100 where there is a requirement of mentioning it in the memo of appeal.
It's not there, but then anytime, my lord, even at the time of hearing also,
Okay.
your lordship finds that
Learned-
substantial.
Learned
question
Senior
of-
Counsel for the appellant submits that though substantial question of law is involved in this appeal, however, same is not yet formulated. He seeks leave of this court to file an additional affidavit mentioning therein the substantial question of law involved in this appeal. The leave is granted. How much time will you require?
I think any affidavit is required. We can file a substantial question of law
In what form?
in a simple form, and your lordship. will
Okay.
take that.
Instead of affidavit, file draft substantial question of law. The prayer is allowed. The appellant may file draft substantial question of law before within 2 weeks. 2 weeks from the date of this order,
Okay.
list accordingly.
If I may, my lord, the LCR has been received, my lord, the matter may be fixed for hearing.
Heard Mr.
Chief Imtiaz.
G. Imtiaz, learned counsel for the appellant. Also heard Mr. B.K. Bora appearing for. How many respondents are there?
No respect.
Appearing for the sole respondent. It is submitted at bar that this case is ready for hearing as the trial court records have been received. Stop. Accordingly, list this matter for hearing. When do you want? It is a 2010 matter. In the month of January on a date to be fixed by registry. January 2025.
Deeply obliged.
Wait, please, your lordship. The matter may be taken after some time.
After some time. Why?
I for the applicant. This miss case is for condonation from delay of 253 days.
Whether notice have been
And
served.
the notice in respect of copy number 21 and 32. One is for insufficient address and next one is not found. I would like to strike up these two. Because for enhancement only, the insurance company, both the insurance company appeared. It is number 1 and 2. 1 Roman 1, New India, and 1 Roman 2, United India. What are represented? It's very old case. 13, I of 13, 2013. As per office note, notice last office note 22/11/2024. Answer notice of 2-1 and 3-2.
Then at least insurance
Insufficient.
company shall have to be heard. Who is appearing for insurance company?
That's it.
Who is appearing for the insurance company?
Insurance company. One Dotto, some Dotto, and another Vermont also there. Two company, New India and first list reflects the names of the
Okay.
insurance company.
Heard Mr. M. Ahmed,
Yes, yeah, Pandit.
S.C. Pandit, learned counsel for the applicant. Stop. On perusal of the office note dated 22/11/2024, it appears that notice issued to respondent number 2 within bracket small Roman 1 and notice issued as well as respondent number 3 within bracket small Roman 2 would not be served for the reasons mentioned therein. Learned counsel for the applicant has submitted that as the applicant has preferred the connected appeal mainly for enhancement of the awarded amount. The respondent number 2 within bracket Roman 1, who is the owner of the vehicle, as well as 2 Roman 2, who is also the owner of another vehicle, may not be necessary for adjudication of this appeal, and hence he prays for striking out the names of the said respondents. The prayer is allowed. The registry to strike out the name of respondent number Roman 1 and Roman 2. Respondent number 2 within bracket 1 and 2 within bracket 3 within bracket 2. 2 1 and 3 2 from the cause title of the memo of appeal. Though the other respondents, namely respondent number 1 within bracket Roman 1 and 1 within bracket Roman 2, are represented by their engaged counsel. However, today no one was found on call. Hence, let this matter be listed again on next week. When?
In January.
On 5th of January, 6th of January 2025.
Your lordship, lordship, my senior is in other court. May you
Why this matter has been listed? You have not taken steps for service of notice on respondent number 7. Instead of directions. What is your prayer? To pass over for the time being. Okay. Let her senior come.
Well, I have question number 2. In this case, it was earlier referred to conciliation, but conciliation paying now.
Should I appear to that I newly engaged counsel in this case?
For the appellant,
For that,
what is your prayer?
my prayer is, Lord, let this matter be fixed for hearing. Lord.
Otherwise, it is ready for hearing.
Yes. Sorry, the record has come that I cannot.
No, whether LCR, I think it has not been this. LCR is, LCR would be required.
Yes, sir, your lordship may call for the.
Heard Mr. Item number
21.
S. Heard Mr. R.K. Dubey.
R.
Dubey, learned counsel for the appellant. Also heard me.
For number 2, madam.
Also heard Mr. S.S.S. Rahman, learned counsel appearing for respondent number 2. Learned counsel for the parties have submitted that though this matter was referred to mediation, however, the effort on arriving at an amicable settlement through mediation has failed, and this case may be settled. This case may be listed for hearing. However, it appears that the trial court records have not yet been received. Issue reminder for the same. Registry to issue reminder. Let this case be listed again after receipt of the trial court records.
After BOV question, my lord, mark BOV. Yes, my lord.
In the month of January, on a date to be fixed by registry.
Right. Please, lordship. Lordship, as per office note dated 1/8/24,
Why this IA is for?
for condonation of delay in filing restoration petition.
Okay.
Lordship, number 3 served, lordship. Whereas lordship number 1 and 2 are concerned. Lordship could not be served as, could not be traced out.
Now what is to be done?
Maybe start of 1 and 2. See,
Who is 1 and 2?
1 owner and 2 is driver.
What for this appeal has been?
Lordship, for enhancement of competition.
Heard. Mr.
And the
M. Talukdar, learned counsel for the applicant. On perusal of the office note dated
1/8/24.
2/12/2024, it appears that the notice issued to respondent number 3 has been duly served. However, the office note dated 1/8/2024 shows that the notices issued to respondent number 1 and 2 could not be served as the addressee could not be traced out. Learned counsel for the applicant has submitted that as the connected appeal has been preferred by the applicant only for enhancement of the awarded amount by the impugned order, the presence of respondent number 2, 1 and 2 may not be necessary for adjudication of the instant appeal. Hence, he prays for striking out their names. Stop. The prayer is allowed. The names of respondent number 1 and 2 may be strike out from the memo of appeal. Who is appearing for 3?
As well, none appeared. Those served.
None has appeared for respondent number 3. We will take it up after Bihu vacation. However, one opportunity is granted to respondent number 3 before this matter is taken up for consideration. Let this matter be listed in the month of January on a date to be fixed by registry.
Nice.
The Lavazima goods order 11/11.
You are also not well. Okay.
It may peruse the order dated 11/11/24 passed by the Lavazima court.
Yes.
Lordship, on account of this order, I'm praying for the last chance to file the IA concern, Lordship. The fact being, petitioner
You have not taken steps
Yes,
for
Lordship, that is reflected in the order, Lordship. The fact being the petitioner, I mean the applicant as well as the appellant here of the case is a very old person, Lordship, of the aged 76, and he on these 2 days we have contacted this concerned petitioner, but he being out of India for medical purpose, so he could not come and for the signing of the thing. We could not arrange the same. So after that, from 2022, it was not listed. So it went out of sight, so we could not.
No, but you could have submitted this before the Lawajima court.
Here, there. They give me last chance before, after the vacation, I will be filing, will be contacting the petitioner, I will be filing the IA.
Otherwise, this IA is for condonation of delay. It will be dismissed for not taking steps. Heard, Miss
IDAS.
Idas, learned counsel for the applicant who submits that as the applicant was staying or had gone abroad, he could not be contacted by the engaged counsel for the applicant, and therefore steps for issuance of notice on respondent number 1 could not be taken, though it was directed by this court as well as by Lawajima court. The petitioner, the learned counsel for the petitioner, prays for one last chance to take steps for issuance of notice on respondent number 1. Considering the submissions made by the learned counsel, the prayer is allowed. One last chance is afforded to the applicant to take steps for issuance of notice on respondent number 1 by registered post with AD and
I need to file an IA for change of the address concerned of the respondent number 1.
okay. To yes. To
IA lordship. Affidavit could not be signed lordship, that's why I could. Lordship may produce 14/11/22 order, judicial order.
take क्या लिखा पल्लवी last time? No. Take steps for correction of address of respondent number 1 in the memo of appeal, and thereafter to
IA concerned lordship. First, it will come in the IA. IA number 1891 of 2020, which is the.
that is for condonation of delay.
Will be corrected.
No, first we will issue notice in condonation of delay only, then the question of
Lordship, I think a notice was issued.
where notice is issued in the condonation of delay application where the address is wrong. So you have to collect the correct address and thereafter take steps. These 2 steps you have to take.
IA, then steps.
Yes. Within how much time?
Vacation. After the new vacation. Is
Within 10th of January 2025. It is hereby made clear that if the applicant fails to take steps as directed, the application may be dismissed for not taking step in pursuant to the directions of this court.
I'm sorry to intervene. But in item 20, there was an time lot. The interim order needs to be extended.
In item 21, the interim order shall continue till next day.
Lordship, my previously office was dated 28/10.
Yes.
I pray, because the service by usual process report is yet to be issued by the section.
No, I am not getting you. What 2810 says?
It says that matter.
Respondent number 1 and 2, it could not be served.
Is matter by the registered process. We have also taken step by usual process also. That is yet to be issued by the section.
Is report regarding usual mode. Okay. You want to await? Okay. Heard Mr. G. Bhardwaj, learned counsel for the appellant. On perusal of the office note dated 28/10/2024, it appears that the notices issued to respondent number 1 and 2 through registered posts with AD have returned without service. Stop. Learned counsel for the petition. Learned counsel for the appellant has also submitted that in this case, the notices were also issued through usual mode, the report of which has not yet been received by the registry, and he prays for awaiting the said report. The prayer is allowed. Let the service report of notices sent through usual mode be awaited. Let this matter be listed after 3 weeks.
May I please your lordship? Lordship, as per the office note dated 21/11/2024, lordship, the steps were taken against the respondents number 5, 18, 20, 21 through postal AD as well as in Israel. Lordship. Services were awaited, lordship. Office note dated 21/11/24, lordship.
21/11.
Lordship. As per the law, the court. Order, Lord. I think lordship that the tag marks 21/11. We took the steps on 19/11.
On 5/18/21,
Lordship,
20 and 21.
in both mode, we took the
The
steps.
report has not yet received. Yes.
I am appealing for respondent number 39, but my name is shown in for this 29. Actually, I am not appearing in the 29, but I am appearing for 39.
Okay. We are taking up item number
27.
27.
Would have been amenable. Yes. Her land record, what I have done. But that's why service is.
No, service report has not
Been received, lordship.
have been received.
That-
No, let us wait for,
No
heard,
respondents.
heard Mr.
SK Sarkar.
S.K.
Lordship.
Sarkar,
Lordship.
S.K. Sarkar, learned counsel for the appellant. Also heard Mr. A.R. Medhi, appearing for respondent number 39. As well as Mr. What is the name? K.M. Halloy, appearing for respondent number 34. Also heard Mr. T.R. Gogoi, learned government advocate, appearing for respondent number 2, 3, and 4. On perusal of the office note dated 21/11/2024, it appears that the appellant has taken steps for issuance of notice to respondent number 5/18, 5/18/2021 and 21. Stop. However, the service report is awaited. Await further. Learned Mr. A.R. Medhi, Learned Counsel for respondent number 39 has submitted that though he has been engaged for respondent number 39, however, in the cause list, his name has been shown wrongly against respondent number 29 and prays for correction of the same. The registry to look into it and reflect the correct respondent number against the name of Mr. A.R. Medhi henceforth. List this matter
After vacation, let's say.
after vacation, after 4 weeks.
Highly
None has appeared for the applicant on call. List this matter again in the next week on a date to be fixed by registry.
Please, your lordship, as per Lozima Court order dated 2/12/2024, service has been completed.
This is delay condonation application.
Yes.
How much delay is there?
23 days.
Heard Miss
Vidas,
B. Das, Learned,
7 days.
or 11 days.
heard Miss B. Das, Learned Counsel for the applicant. None has appeared. Now, on perusal of office note dated 9/12/2024, as well as order of the Lawajima Court dated 2/12/2024, it appears that the notices issued to respondent number issued to the sole respondent / opposite party has been duly served. Stop. Duly served. Stop. I have also perused the service report. After considering the order of the Lawajima Court as well as the service report, the notices issued to respondent number 2 is held to be duly served. Stop. This application under section 5 of the Limitation Act 1963 has been filed by the applicant for condoning the delay of
11 days.
11 days in preferring the connected regular second appeal. Stop. The after considering the submissions made by learned counsel for the applicant, as well as in which para you have mentioned the reasons for delay?
Paragraph 5, page number 6. So the second appeal.
Mentioned in the condonation of delay application, this court is satisfied that the applicant was prevented by sufficient cause in preferring the connected appeal within the period of limitation. Hence, the delay of 11 days in preferring the connected appeal is hereby condoned. Let the connected regular second appeal be registered and listed for admission by the registry after vacation. This interlocutory application is accordingly disposed of. None has appeared for the appellant on call. On perusal of the office note dated 27/11/2024, it appears that the notices issued to respondent number 1 within bracket G as well as respondent number 2 have been duly served, whereas notices issued to respondent number 1 within bracket small a has returned with an endorsement that the addressee has expired. The appellant may take appropriate steps as regards respondent number 1 within bracket A in view of the death of the said respondent. Let this matter be listed again after winter vacation, after 4 weeks.
Lordship is told the respondents and that if the records have also come.
So it is ready for hearing. Heard Mr. G. Bhardwaj, learned counsel for the petitioner and learned counsel for the appellant, and also heard Ms. A. Saha, appearing on behalf of Mr. B.J. Mukherjee, learned counsel for the sole respondent. The office note dated 5/12/2024 shows that the records of the first appellate court as well as the trial court have been received. Hence, this appeal is ready for hearing. List this appeal for hearing in its usual course.
For condoning the bill level 16 days.
How many days?
16 days, 1/6.
16 days.
My lord, in my application, my lord, it is a court order 132 days. 16. Sure.
16 days. But there is a reflection that 132 days.
Yes, yeah, in my also 132 days here. 16 days, my lord. It's corrected, my lord, 16 days.
Then why it is mentioned that 132 days?
In
You have mentioned in your application 132 days.
24, 1,
In your
24.
delay condonation application, you have stated that 132 days delay.
Right. Office commission, it is 16 days, my lord.
Why the delay? It is 132 days. What is the submission?
Submission, my lord, as per my lord, record, my lord. In the connected appeal, my lord. It is reflected as 16 days, my lord.
No, we'll not go by connected appeal. First, you have to convince the court
Right.
that the delay is
16 days, my
condonable.
lord. It is there as per.
Then you correct your,
Lordship. It should be correct.
let him correct.
Yes,
You verify how much delay has.
as per record, my lord, it is 16 days, my lord.
Then why have you mentioned 132? This is your petition.
Lord. In my office copy, it is 16 days, my lord. Lord,
Office copy is yours. The petition is also yours.
24 January ordered, there is 132 days.
Because in the petition, it is 132
Yes.
days. Heard Mr. A.T. Sarkar, A. Mubarak, learned counsel for the applicant. Also heard Mr. P.K. Deka, learned counsel for the
Solid.
sole respondent. Learned counsel for the applicant submits that though in the application for condoning delay in filing the connected appeal, it has been mentioned that total 132 days of delay has been caused in filing the connected appeal. However, from records, it appears that actual delay is of about 16 days only. He submits that he may be granted some time to verify the same and if required to rectify the error in the application by filing the required amendment petition if required. The prayer is allowed. Let this matter be listed after reopening of the court after winter vacation.
Bless.
I'm taking 1 minute break. G. Bhardwaj appearing for? You are appearing for all the legal heirs. Legal heirs of respondent number, sole respondent. This application under order 22 rule 4 read with section 151 of the Code of Civil Procedure, 1908 has been filed by the applicant for substitution of the legal heirs of the sole respondent Kailash Chandra Parekh, who has passed away on 3/8/2024. It appears on perusal of the averments made in the application that this application is made within the period of limitations. Moreover, learned counsel for the moreover, there is no objection to the prayer for substituting the legal heirs of sole respondent. Hence, the prayer is allowed. The names of the legal heirs of
Actually, schedule loss. Page detail.
where have you mentioned?
Page 18, page, paragraph 2 is also there and schedule is there. I mentioned the single schedule. Page 18.
Legal heirs of the sole respondent as reflected in the schedule annexed with this substitution application may be incorporated as respondent number 1A, 1B, and 1C in the memo of appeal. You will file the substitution will be done by the registry. The registry will make necessary substitution by in the memo of appeal in pursuant to this order. This interlocutory application is accordingly disposed of.
Much obliged.
Now, Pallavi, last line की लिखी चले registry. Yes.
Matrimonial appeal, my lord. And initially, I have filed IA for my lord, condoning the delay. According to notice was issued, my lord,
Delay was condoned.
condoned.
Okay.
But no representative, my lord, till that present, my lord,
We will issue notice.
my lord.
You are challenging.
My lord, judgment dated 11/8/2023, my lord, page 60.
By which what was
District Judge, my lord, Lakhimpur.
your wife or husband?
Then, my lord,
Divorce was allowed.
allowed
Okay.
permanent alimony of 10 lakhs, my lord.
Heard Mr. K.R. Padgiri, learned counsel for the appellant. This appeal under section 28 of the Hindu Marriage Act, 1955 has been filed by the appellant, Sri Manik Rajkhwa, impugning the judgment dated 11/8/2023 and decree dated 16/8/2023 passed by learned District Judge Lakhimpur in title suit within bracket divorce number 41/2019, whereby the decree of divorce was granted. Who was the plaintiff in the
My lord, the respondent, my lord,
granted to the respondent and a permanent alimony of rupees 10 lakh was also awarded. Issue notice, this appeal is admitted. Stop. Issue notice to the respondent. The appellant shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 30th of January 2025. Let the records of trial court be called for registry to take step for requisitioning the aforesaid records. List accordingly.
all right. My lord, in this case, appellant also expired very long back. And he has no legal representative also. So appeal is everything.
You are for the appellant. When he expired,
Expired in sometime it's 2018.
what is the evidence regarding
We issued,
death certificate is there?
we issued letter to them. But the wife come, they he expired. Then one criminal case was also there. On that criminal case, the report has called for from the OC was that report submitted in that criminal case yes, expired.
When has appellant expired? Date, year,
That they have not mentioned my lord. I কোনো মানুষের নাই।
at least some information has to be there.
That's why I cannot come because.
Because you are informing the court under 10A.
I will produce the relevant records.
We are fixing it in the first week of January. You inform the court at least some concrete
Yes,
information.
because we cannot collect the death certificate. That is why court
No, even if you do not collect the death certificate under 22 rule 10A, you have to inform the court. You are informing, but the information has to be just saying that appellant has expired, at least in which year, which month.
because I issued letter to them in 2019 and the wife come. Said I expired, we are not interested to proceed this.
Now, when wife told you he has expired, you should have asked when he has expired.
Silent.
Heard Mr. J. Ahmed, Planet Counsel for the appellant. Also heard Miss
Yadav, for respondent number 1 and 3 on behalf of Mr. T. Islam.
Miss R. Yadav appearing for respondent number 1 and 3. Learned counsel for the appellant has submitted that he has been informed by the wife of the appellant that appellant has expired. However, he seeks some time for furnishing concrete information regarding the date of death of the appellant. To this court. The prayer is allowed. Let this matter be listed in the. When should you? In the 3rd week of January.
As per office note dated 2/9/2024, my lord, service of the respondent number 1 and 2 has been duly served, my lord. Service is complete, my lord. Let the matter may come for admission.
What is this?
That matter, the notice was issued in this case, next admission letter that will come up for admission.
No. What you are impugning?
2024.
No, I'm not asking you. Which order you are challenging? What has been
29/12/2008 order passed in WC case number 32 of 2005.
It has not yet been admitted. Okay, heard. Miss
That's right.
S. This is item number.
18.
Miss S. Roy, learned counsel for the appellant. The office note dated. Which office note?
Honorable Court's order dated 2/9/2020.
It appears from record that the notices issued to respondent number 1 and 2 have been duly served. Stop. However, none has appeared for the respondent number 1 and 2. Let this matter be listed for admission in the month of January. In the second week of January on a date to be fixed by registry.
My lord, the service is complete. And these matters, in fact, my lord, we have compromised. Your lordship will find the compromise petition is on record. That is,
Why this IA is for?
yes, my lord, we have compromised the matter in terms of order 23.3.
Okay.
Your lordship look at paragraph 7. These are the terms of
Page.
page 10, my lord. Page 10, paragraph 7. IA number is 3205.
Yes.
Lord, para 7, you lordship find that with the intervention of the well-wishers, the appellant, plaintiff, and respondent defendants has amicably compromised the case on the following terms. That in terms of the compromise, the respondents admits the fact regarding the execution of the deed of agreement for sale dated so and so by their predecessor, namely so and so, so and so. Received advance 2 lakhs out of settled consideration of 18 lakhs. The respondent further admit that their predecessor also received another sum of 6 lakhs as further advance from the appellant. In this way, the predecessor of the respondent received total advance rupees 8 lakhs. And in terms of compromise, the respondents further declared that at the time of submission of joint compromise petition dated so and so before the appellate court in title appeal number so and so, they received balance consideration of rupees 10 lakhs from the appellant by check number so and so. Acknowledge and also acknowledges that respondent received the entire consideration of 18 lakhs. It is further admitted that in view of receipt of entire consideration money on so and so, the respondents handed over physical possession of the land in favor of the appellant in respect of which the deed of agreement was executed on 25/8/2021. And now appellant is in possession of say 6 cutters of land and developing the same. Both the parties filing this joint application before this honorable court in RSA number so and so under order so and so, as well as setting aside decree dated 23/6/2023 passed by the civil judge number 1 Silchar entitled suit number so and so, and also setting aside decree dated so and so passed in by district judge Silchar entitled appeal number so and so. But in terms of this compromise, the respondents agreed to execute and registered the sale deed on acknowledgement of receipt of entire consideration of 18 lakhs from appellant within 1 month from the date of decree. The respondents have no objection if the present appeal is allowed and compromised without cost. But in terms of this compromise, the respondent further declared that if the respondent fails to execute and register the sale deed within 1 month from the date of decree, then the appellant shall be entitled to get the sale deed executed through the process of the court. Now, these are the terms of agreement, my lord. And in terms of that, my lord, the decree can be passed by modifying the order of the learned in chief and the district judge.
What was the
In both the courts, my lord, they have discussed. Although, my lord, we filed a compromise petition before the appellate forum also. My lord, they have discussed. Now we filed the second appeal. In second.
you have executed a deed of compromise?
Yes,
Where?
there in the appellate forum, but it was not taken care of. And ultimately title appeal was also dismissed. Then we filed second appeal here. Now, second appellate stage, since my lord, they have received the entire amount.
No, why it was not,
But these are on a, my lord, we vote.
why compromise was not taken note of by the first appellate court?
The finding of the district judge at page 17,
Of the,
the appeal member, appellate judgment, it starts from page 18. The finding your lordship will find, my lord, at page 46.
yes,
Page 46, paragraph 25, your lordship kindly see. Merely proving that permanent structure was built on the sole plan within 5 years of tenancy is not enough when the primary question here is whether pre-reserve of the defendant was granted such lease deed or not. As a said lease deed number so and so in the year 1964 of the office of the joint sub-register, which itself is not proved. Hence, court on mere saying cannot imply that there was lease deed executed between predecessor of defendants and Mahmud al-Haq, Majumdar and 7 others. Also, there is no document to prove that deceased Vijitendra Narayan Paul regularly paid the annual rent to the landlords, namely so and so and others. As the foundational facts of lease itself are not proved, court cannot assume that the deceased Vijit Narayan Paul acquired the status of non-evictable tenant under the Assam law. Well, these are the things.
no, what was the case between the parties?
Specific performance of contract.
There was
They
a,
entered into contract with us that we pay rupees 18 lakhs and out of 10 cutters, we are going to sell.
whether the respondent, there is a relationship between plaintiff and respondent. They were strangers.
They are the third party. So, my lord, entire, my lord, these considerations are totally illegal. My lord, if I remain there for 5 years and within 5 years I make a permanent construction, that itself is sufficient. And these are not the disputed thing. Nobody disputed. It was picked
No,
up by
no,
the.
my query was different. Whether the settlement was arrived at the first appellate stage itself, whether it was informed to the court that the, then why it was rejected?
The lordship said these are the findings. My lord. He did not go into that.
No, but it does not reflect about the settlement.
Go to that at all. That is our grievance. And we have taken the point in the second appellate stage also.
But in spite of the parties reaching an amicable settlement,
That is the thing, my lord, in my professional career, I did not find this kind of thing. When both the parties are coming up for a compromise and there is no dispute in question of law, question of facts. Nonetheless, my lord, the learned judge has made some third case in that, which was not required to be adjudicated at all. Nobody asking for that sort of adjudication. Nonetheless, he has ventured to go to that extent. It was not necessary at all. Ma'am. And the person from whom the predecessor of the respondent has got the land, that there is also no dispute. Now, there is no point of fishing out all these things, that whether there was a lease, whether 64 lease was valid or not. Who is asking for that? Who is disputing?
where is the deed of agreement?
Page that you will find is at page 67. my lord. In second opinion. Joint compromise.
What order was passed on this?
My lord, it was not taken into consideration at all.
Okay. No, this is the joint compromise petition.
Yes,
Whether any deed has been executed apart from the petition, no.
apart from this compromise petition. The compromise deed was not there, this application was made. By both the parties.
Now, what is your prayer? Why this IA has been filed?
This IA, my lord, as your lordship has seen in paragraph 7, the terms of compromise. In IA 3205, page 10. Paragraph
Understand.
7 from A to E, my lord, we have E to F. These are terms and conditions. Well, otherwise it is all materialized because we are in possession of the land, 6 cutters of land, and they have got 18 lots. Now it appears, my lord, the court is in the way.
Now, what is the compromise that you will sell?
Yes, sir, these are all materialized. It's only thing agreement, they will enter into an agreement because they have received 18 lakhs in terms of our agreement dated 25/8/2021. So now after, my lord, the decree is passed after modifying both the decrees. Then, my lord, within 1 month, my lord, our prayer is that they will come under an agreement. My lord, your lordship may see
Yes.
how the appellate court dealt it. Paragraph,
You have
Paragraph-
anything to say?
paragraph 6 and 7.
As your lordship has seen, in terms of paragraph 7, we have already received the entire consideration amount of 18 lakhs.
As
And
both
we
the
are-
parties have approached the same chamber, so there must be genuine intention to compromise the matter.
And the matter has been dealt by the appellate forum at page 23, if your lordship see. Paragraph
23 of,
appellate judgment. Appellate. Paragraph 6 and 7.
Page?
Page 23. Paragraph 6.
yes,
6 and 7. It is pertinent to mention here that during pendency of the appeal number so and so, the defendant respondents appeared through Sri Biplab Paul, who represented the other defendants number 1, 3, and 4. The strength of power of attorney and submitted joint compromise petition number so and so with a prayer for passing joint compromise decree. From perusal of petition number so and so, it appears that the said petition is filed with the plaintiff of title suit number so and so, Sri Rajat Ghosh and Sri Biplab Paul. The defendant number 2 of title suit number so and so representing Vijay Paul, Shastika Paul, and Madhumita Gupta. The defendant number 1, 3, and 4 of the title suit number so and so. Along with the said petition, copy of one power of attorney has been annexed, authorizing Biplab Paul to represent others in the title appeal number so and so. From perusal of the joint compromise petition, it appears that the defendants respondents have admitted the claim of the plaintiff and also stated that they have no objection if the appeal is allowed on compromise. In the said compromise petition, it has also been mentioned that if the respondent failed to execute and register the sale deed within 1 month from the date of decree, then the appellant shall be entitled to get the sale deed executed through the process of court. It is pertinent to mention that here that now this is suffice to do.
no, why it was not allowed?
Then-
What reasoning is given?
That will get para 7. It is pertinent to mention here that the title appeal number so and so has been preferred against ex parte judgment and decree dated so and so passed by the appeal by the learned civil judge number 1 in title suit number so and so. From perusal of the said ex parte judgment, it appears that the learned trial court dismissed the title suit number so and so and held that the plaintiff is not entitled to get a decree for a specific performance of contract of sale of suit property on the ground that
the plaintiff failed to prove his title in that suit. Thereafter, on being aggrieved by the impugned judgment, the title appeal number so and so was preferred, and during pendency of the appeal, the joint compromise petition was filed. As the learned civil judge number 1, Kachar Shilcher in the judgment clearly held that the plaintiff failed to prove his title over the suit land. Therefore, until and unless the said judgment is not set aside, reversed, the joint compromise petition cannot be allowed. As the joint compromise petition contains some terms and conditions which are directly in contrast with the finding of the learned trial court, if the impugned judgment, hence the joint compromise petition is taken along. with
Okay,
the-
how will you address this?
But
It says that the plaintiff does not have the title.
now, this is not in question.
No, but suppose if you don't have the title, then how can you convey that title to other?
Here is that there is an agreement between us. Now, the specific.
But the
performance of-
compromise has to be lawful.
Now, your lordship can listen. The plaintiff. Now, here the question is very simple. The respondent is the title holder of 6 cutters of land. Now, the plaintiff is not the owner of the land. And the respondent is saying that on terms of getting 18 lakhs, we shall go for an agreement that we shall sell the land to the plaintiff.
Which land?
Land of the respondent, 6 cutters of land.
Respondent was the,
It's the owner of that 10 cutters of land. Out of 10 cutters, they will sell 6 cutters.
now then what is this observation that
This is, my lord, is a perverse finding. From where is getting all that? My lord, your lordship, can you see what is our case? We are asking for a specific performance of contract.
No, before that, I have to understand. Your agreement has, the compromise has to be lawful.
Yes.
It cannot be against a law. So it cannot be against a judgment also. If judgment is perverse, you have to show that there is a wrong observation. It says that judgment clearly held that the plaintiff failed to prove his title over the suit land.
My lord,
How will you address this?
see one thing, whether this question is a valid question or not. Now, how I am going to, I am asking for specific performance of contract. Now, in regard to 6 cutters of land, it is not my land that I will have to prove that the plaintiff is the owner of this land. The owner is the respondent.
Okay,
Respondent is the owner.
you were the purchaser.
I am the purchaser. So this question itself is the wrong question. And without understanding.
Where is this observation in the judgment? The judgment which the title appeal 7 refers to. Where is the observation in the title suit? Let us see once. Because for allowing the compromise, we have to overcome this observation.
Please. 46.
The observation made in page 24.
Your lordship, can you see page 46, para 24? 25, I have read already. 25
Page?
and 26.
Page 46.
46. Your lordship already read that.
46 is the judgment of the trial court.
Trial court.
Para
Para 25.
25. Yes.
Merely proving that permanent structure was built on the suit land within 5 years of tenancy is not enough when the primary question here is whether predecessor of the defendant was granted such lease deed or not. As the said lease deed number so and so for the year 1962 with the office of the joint sub-register Shilcher itself is not true.
Hence, quote on mayor saying cannot imply that there was lease and executed between predecessor of defendants and Mahmud al Haq, Majumdar and others. Also, there is no document to prove that deceased Vijitendra Narayan Paul regularly paid the annual rent to the landlords, namely so and so, so and so, as the foundational facts of lease itself are not proved. Court cannot assume that the deceased Vijit Narayan Paul acquired the status of non-evictable tenant under the Assam Non-Agricultural Urban Areas Tenancy Act.
Who is the respondent in this case? Vijit Narayan.
Yes, earlier it was Vijitendra Narayan. Now he has expired, then his son Diplok Paul and all. The respondent now, 1, 2, 3.
Now, the observation of the trial court that Vijit Narayan Paul has has not acquired the status of non-evictable tenant. It is in respect of which land? This 6 Katha land.
Respect of 6 cutters of land.
So you were earlier tenant.
No, no. I just had a contract with them that they, out of 10 cutters of land, they will sell 6 cutters of land.
No, let me understand.
I was not.
The respondent. Who is the
The
respondent? here?
respondents, they have purchased from my lord,
Purchase.
yes,
Where is that?
that your lordship will.
Who is the respondent? Vijit Narayan,
Vijitendra.
the legal heirs of Vijit Narayan.
Right, right. Now, your lordship may see at page 19. Paragraph 3. There are 3 your lordship will find. The brief facts of the plaintiff's case are that the predecessor in interest of the defendant Vijitendra Narayan Paul, alias Vijit Narayan Paul, took settlement of the land measuring 10 acres within definite boundaries mentioned in the schedule of the claim, along with other lands from the sons of late Abdul Karim and 7 others. The strength of bilateral registered lease deed bearing number so and so.
Lease deed.
Yes. And the said lease deed was executed on 10/3/1964 and registered on 25/3/1964.
So the predecessor in the interest of the respondents were the lessee in respect of 10 kathas of the land. Thereafter,
Thereafter, then your lordship will find pursuant to the said lease, predecessor interest of the defendant Vijitendra Narayan Paul had been delivered cash possession of the said 10 kathas of land within definite boundaries, and said Vijitendra Narayan Paul registered holding in the Silchar municipality in his own name and within the knowledge and acquiescence and in terms of the lease deed of the above mentioned landlords constructed permanent structure thereon after taking necessary permission within 5 years of taking lease, and thus Vijitendra Narayan Paul acquired non-evictable tenancy right over the entire land, and said Vijitendra Narayan Paul regularly paid the agreed annual rent to the landlords. Vijitendra Narayan Paul also in front part outside the suit land constructed 3-story residential buildings. That unfortunately Vijitendra Narayan Paul developed cramp in his hand and was unable to write, and Vijitendra Narayan Paul, the predecessor of the defendant, being in need of money, proposed to sell the entire suit land and the Maliki right of the house to the plaintiff, and after due discussion between the plaintiff, the predecessor of the defendants, the price of the suit land and Assam type house had been fixed at settled at rupees 18 lakhs. The predecessor of the defendant, Vijitendra Narayan Paul, as advance price received a sum of rupees 2 lakhs only in cash from the plaintiff.
no. Now stop, Mr. Datta.
This is the story.
The story is what I understand, that the predecessor in interest of the respondent, Vijitendra Narayan Paul, took the 10 kathas land on lease. And he claimed that he constructed permanent structure over that land, and therefore by virtue of the provisions of Assam non-agricultural areas
Became non-evictable.
he acquired non-evictable tenancy rights. And those rights he intend to sell. Out of that 10 kathas, he sold 6 kathas to
The present response.
he agreed to sell,
Agreed to sell.
and thereafter he
rupees 18 lakhs.
received rupees 18 lakh, and thereafter he denied. And therefore you filed a
Then
suit for specific purpose.
deny. It's not going for because the sale permission.
He was
could
not
get.
registering.
Yes, registering was delayed because he could not get the sale permission. Then he was delaying the matter, therefore we filed a suit.
Now,
same
now
purpose.
the observation of the trial court is that you never acquired non-evictable tenancy rights.
What is the use of going to that, my lord? Who has disputed all these things? So the court will, my lord, when there is a lease, the court will go into that. Is a non-issue for the plaintiff and defendant. Now, court is fishing out something else. Now, what will happen now? My lord, the earlier, on the first owner, he is no more. Then the land has come to, he is a non-evictable tenant. He want to sell it and he has already taken the money. And there is an agreement, he is ready to go for agreement and all that.
How to transfer this non-evictable tenancy right? This is not transfer of ownership.
Transfer, my lord, once it is a non-evictable tenant.
Is it equal?
In fact, my lord, the earlier owner cannot claim anything from him. Because it's a permanent settlement.
It
So
is
therefore, it is up to him.
whether right acquired under section 5 of that act, 5 or
I think 5.
5, then whether it is an alienable right, whether
Yes. There is no doubt about it.
it is this right can
transferable.
be transferred by a registered, what is the mode of transfer?
Registered sale. And in fact, these are in all process. They have got, in the meantime, my lord, I am told that they have obtained the sale permission also.
But to obtain sale permission, it appears that the observation made by the trial court that you have failed to prove your title over the suit land have to be overcome.
Lordship, go to the plaint. The lordship will find that what is the plaintiff's case and what the learned judge has decided. Because the court cannot decide something which is not in the pleading. And here is, my lord, the court is asking that the buyer will have to approve his title. They absolutely in a reverse here.
No, what is your submission regarding the observation made in para 25 of the ex parte judgment
The suit.
in the suit, title suit 10?
Paragraph 25.
Yes.
Early provision from
Suit was dismissed
suit was dismissed. It was
for this reason,
ex parte judgment.
ex parte, but it was dismissed because of this reason.
Yes.
How will you overcome it? You have to satisfy.
Now here, your lordship, kindly, I'll take again to your lordship to the plaint. What you
Plaint.
stated there, the specific performance of contract. Now, what is?
No, assuming I'm giving a different case. Suppose A files a suit for specific performance of contract against B, that B had entered into a contract to sell his land. And in the suit, it was found that he was not the owner, whether a decree for specific contract can be issued.
Where the learned judge is getting
Okay,
that.
there is no material, that is your word.
It is just a thinking or Lord, the perception of the learned judge. Rather, I would say wrong perception. Lord, you will give a finding on the basis of some material. Where are those materials?
No, let us read 25 again. The observation which is
Here,
coming into your way.
proving that permanent structure was built on the suit land within 5 years of tenancy is not enough. When the primary question here is whether predecessor of the defendant was granted such lease deed or not. As the said lease deed number so and so for the year 1964 of the office of the joint sub-register, Silchar itself is not proved. Hence, court on mayor saying cannot imply that there was lease deed executed between predecessor of defendants and.
Whether this lease deed was in dispute,
No, no, no. Nobody raised any question.
there
That's
was
why I'm saying, my lord, from what materials the learned judge is saying all these things.
no, he filed a written statement in your suit.
No, no, that was.
Oh, that was an ex parte.
That's part.
Okay.
These are not disputed at all, my lord. It is just perception of the learned judge. He's thinking that lease was not good lease, it was invalid. Now he was thinking. And merely because he was thinking that, he has given in written.
In a ex parte judgment, you have to, even in an ex parte judgment, you have to prove basic facts.
Now here, I will have to.
What evidence was led?
Very right. But since it is in the plaintiff that specific purpose of a contract. Now I am required to prove that I have done my duty and the other side did not do that. And I have come because of that only,
And other side was the owner.
other side. So they will.
You
have to-
led evidence.
We have done our part.
How many witnesses were reduced in the suit? The trial court is saying that as the deed was not proved, therefore it came to the finding. Lease deed was not proved.
Say that who, from where is getting that? Who has controverted all that?
Yes, that is one.
A judge cannot make out a case. He will have to be, on the pleadings of the parties. Your lordship look at page 48. The lordship will find exhibits, that is the deed of agreement for sale. The defendant none, witnesses PW1 and PW2. And there is no written statement saying that the lease deed was not valid. And in absence of all these things, the learned judge has given the finding that lease deed was not valid. Now, it is all his written statement. So possibly court has filed a written statement and he's giving a finding on that. I'm constrained to say that only.
Okay, your submission is that the fact that the plaintiff has acquired non-evictable tenancy right was never questioned by anybody. So this was not at issue in the suit.
These are all non-issue. And when in a specific performance of contract,
Okay,
only thing to be seen that what whether we have done our duty or the other side has failed to do that.
okay. Anything else? I'll go through the records. I'll reserve the judgment. I'll go
If your lordship want any explanation, your lordship can.
if
come.
I have any query, I will put the query.
Definitely.
But let me go through the evidence. Because if your IA is allowed, then automatically the RSA will be disposed of in terms of the orders passed in IA.
You have to modify both the orders of both. Decree of both.
In terms of if IA is allowed. If IA is disposed of, then RSA will continue.
Then your lordship will go into that.
Okay. Then let me go through the evidence. In This interlocutory application heard Mr. S. Datta, learned senior counsel, assisted by Mr. A. Bishwas, learned counsel for the applicant slash appellant. Also heard Mr. S. Datta, learned counsel appearing for the respondent,
The applicants.
as well as this is a joint application.
Joint.
Applicants. This joint application under Order 23, Rule 3 of the Code of Civil Procedure 1908 has been filed by the appellants as well as the respondents of RSA number 116/2024, inter alia, pleading that they have arrived at a amicable settlement, compromised settlement between themselves, and the regular second appeal may be disposed of in terms of the settlement arrived at between the parties. Stop. I have heard learned counsel for both the sides. Though this is a joint application filed under Order 23, Rule 3 of the Code of Civil Procedure, 1908. However, in view of the observation made by the First Appellate Court in paragraph number 7 of the impugned judgment, this court intends to go through the records are there. Let's see. Go through the evidence of the plaintiff's witnesses, on the basis of which the ex parte judgment was passed by the trial court. Hence, the order is reserved.
Apple 3 application.
Putul. Yes,
And have 3 application, one for substitution and one other for delay continuation and for setting aside.
setting aside what?
Setting aside abatement. But my lord, I find they have filed in one objection to my delay petition, my lord, which is not on record.
Now, first, which application we will take up?
Delay petition, my lord.
Delay for setting aside abatement
No, no, my for conditioning the delay,
for?
preparing the substitution petition.
No, you cannot substitute without setting aside abatement. First, abatement has to be set
Yes,
aside.
my lord, then application 3446.
If there is a delay in filing setting aside abatement, then a condonation petition has to be there.
Yes. ma'am. Yes.
Whether have you filed that
No, my
condon?
lord, I have not filed separately, but I have
The,
explained in this application.
a separate application is required because suppose your delay in preferring setting aside abatement application is not condoned, then abatement is not condoned. Then the question of substitution does not arise. There has to be 4 applications.
Yes, my lord, what the registry do, my lord, we file for application, but they return the application file for setting aside the amendment. Every time they do that,
They cannot do so.
every time. Or we say you give a note requiring us to withdraw. They say, no, you on your own withdraw it. Then I will file a separate application.
They have to file an application.
I will file. Yes, my lord, we have been filing. But they have filed two other application also, except this. No, first that has to be, and two other.
Okay.
two other separate
No,
applications.
let them file an application, then we will hear it.
Yes,
Third, Mr.
SK Chakraborty.
S.K. Chakraborty, learned counsel for the applicant. Also heard Mr. This application will be in setting aside abatement.
Yes,
Petition-
correct.
Petition number
3446, man.
3446 in 3446. 3446. In 3446. Mr. S.K. Chakraborty also heard Mr. K. Sharma, learned counsel for the opposite parties. Learned counsel for the applicant has submitted that though this application for setting aside abatement of the appeal is filed beyond the period of limitation, how much delay is there?
Actually, as per our calculation, my lord, it is 1446 days, but the registry has calculated as 12 days. That is meant that the COVID period has been exempted.
So, क्या लिखा? Limitation, however, no separate application for condoning the delay in filing the application for setting aside abatement has been filed, and he seeks leave of this court to file an application for setting aside for condoning the delay in filing the application for setting aside abatement. The prayer is allowed. How much time we let this matter be listed after 4 weeks. In the meanwhile, the applicant may file the application for setting aside for condoning the delay in filing setting aside abatement as prayed for. Please
Yes,
record it. Heard Ms. F. Ahmed, learned counsel for the applicant. Also heard Mr. M. H. Raj Bhuya, learned counsel for the respondent. This application under section 5 of the Limitation Act 1963 has been filed by the applicant / appellant praying for condoning the delay of 14 days in filing the substitution petition, substitution application for substituting the legal heirs of deceased respondent number 7. The learned counsel for the respondent has not raised any objection to the prayer made by the petition applicant. Stop. Moreover, considering the submissions made by learned counsel for the applicant, as well as grounds mentioned in the application, this court is of considered opinion that the delay of 14 days in filing the substitution application has been sufficiently explained by the applicant. Hence, the delay of 14 days is hereby condoned. And this interlocutory application is accordingly allowed.
Lordship, 3530 is for the substitution of the legal heirs of respondent number 7.
Heard Ms. F. Ahmed, learned counsel for the applicant. Also heard Mr. M. H. Rajbur, learned counsel for the respondents. This application under Order 22, Rule 4 of the Code of Civil Procedure, 1908, has been filed for substituting the legal heirs of the respondent number 7, who has passed away on
Lordship, 1/5/2024.
1/5/2024. Stop. It is pertinent to mention hearing that there was a delay of 14 days in filing the substitution application, and same has already been condoned by this court in IA number
3534.
3534/2024. Who are the legal heirs?
Lordship, mentioned in paragraph number 2.
Considering the averments made in the application as well as submissions made by the learned counsel, the prayer is allowed. The legal heirs of respondent number 7, namely Rashmi Begum, within bracket daughter, and Babu, within
son,
bracket minor son,
represented by his father.
represented by his
Father, Abdul Rashid.
father Abdul Rashid, are allowed to be substituted as respondent number 7A and 7B in the memo of appeal. The registry to make necessary corrections in the memo of appeal. This application is accordingly disposed of. In main appeal, main appeal is listed today.
Oh, Lordship,
Let this matter be listed again after a week, after making necessary substitution as directed by the order dated 12/12/2024, passed in IA number
3534 and 3530.
3530/2024.
May it please your lordship, this is an application for substitution of of legal heirs of respondent number 1.
Within time.
Yes, lordship. The respondent has died on 7/10/2024.
Sole respondent.
No, your lordship, respondent number 1.
Any objection?
Actually, my same station.
But there may not be any objection. It is within time.
Time, your lordship.
You are appearing for?
I'm on behalf of M. Bhattacharjee,
Okay, who has died?
respondent number 1. It is on page 6, your lordship, paragraph number 2.
Heard Miss K. Sharma, learned counsel for the applicant. Also heard Miss, what is her name? C. Bora, appearing for Miss M. Bhattacharjee, learned counsel for respondent number 1 and 2. This application under Order 22, Rule 3, How it is rule 3? Why it is rule 3? It has to be rule 4 because respondent has died. What is order 22 rule 3? It is in case of death of plaintiff or sole plaintiff. Order 22. Who has died? Respondent has died. Order 22, read with section 151. Go through rule 3 and 4. CPC for substitution of legal heirs of respondent number 1 who has expired on
7/10/2024.
on 7/10/2024. As the application has been made, application for substitution has been made within the period of limitation. The legal heirs of respondent number 7, namely Revati Devi Sharma, Sunita Mishra, number 3 Pradeep Sharma, Priyanka Sharma, Sandeep Sharma, and Neha Sharma are allowed to be substituted as respondent number 1 within bracket small a to 1 within bracket small f in place of respondent number 1. The registry to make necessary correction in the memo of appeal. This interlocutory application is accordingly disposed of. In main appeal, after making heard so and so, after making necessary correction in terms of order passed in IA number 3672/2024. This matter may be again listed in the first week of January.
Sure, it may be fixed.
Mhm. Yes, what is this? Early hearing, expeditious hearing of the RSA. You have any objection? You are appearing for? Mr. Bhattacharya, you are appearing for Gov.
4 to 8.
When do you want?
February. January is almost.
This is RSA of 2021.
So only one morning, she should be standing this side by now. Now it's getting confused. She should be standing this side. She's the respondent.
You are respondent. Who is the appellant?
Go that side.
This is an IA. Because an IA by me.
No, that is different.
No, but he is right. He is right. Otherwise, court is confused because
I am also for the government. No, I also get confused.
change side.
Because now another thing, my lord, very important from my lord's point of view. In every case, they are trying to make the government pro forma defendant. Now that is very dangerous, my lord.
In civil appeals.
They are in the lower court also. The pro
Mm.
forma word. Just when they come to high court, they would add the word pro forma. Now,
No, you are respondent. Heard Miss Ida's.
I'm supporting the IA, my lord.
Okay, heard Miss Ida's learned. When the decree was passed, it was dismissed. Suit was dismissed. Then in first appellate court? Allowed, okay. Therefore, you are facing.
It was dismissed. They have it out as a RSS.
There are
They-
concurrent findings of the both the lower courts against the appellants.
Okay, and appellants were the defendant plaintiffs.
This is
Okay.
a bit unusual, my lord. The counterclaim was allowed, not the respondents. That means the respondents, we were the main respondents, the government. We were just made parties to inform for effort.
Heard Miss Aidas, learned counsel for the applicant. Also heard Mr. K. Bhattacharya, learned counsel appearing for respondent number 10, 11, 12, and 13, as well as Mr. F. A. Zaman. F. and Zaman appearing for respondent number
For the applicant.
for the appellant opposite parties. This application under section 151 of Code of Civil Procedure 1908 has been filed by the applicant respondent, praying for an early hearing of the connected regular second appeal number 70/2021. The said appeal was filed in the year 2021. When was the order of the first appellate court? Two thousand 2021. Stop. The prayer has not been opposed by the counsel for the opposite parties. Stop. Considering the submissions made by learned counsel for the parties as well as averments made in the petition, this court is of opinion that this case is a fit case where direction for early expeditious hearing may be issued. Accordingly, this case may be listed for hearing in the first week of February on a date to be fixed by registry. This interlocutory application is accordingly disposed of.
I am the respondent, number one, two, three, case number 3, my lord. In this case, we are hearing. 2 weeks time may be allowed for filing a opposition. I have.
This is for impleading.
Statement application, your lordship, we are the respondent in the regular second appeal that they have filed against the dead person, your lordship.
No, my lord. What is false? They are quite distant that they are not the party in this case. If that is, I may be allowed to file any
Was
opposition.
the plaintiff, your
They are quite
lordship.
distant that.
No, one by one. One by one.
It's taking some time, but.
No, let her make, what is this petition? Impleadment application.
For impeding the applicant as respondents, number 1 to 5, your lordship, as because Jamaluddin was the plaintiff, in the title suit. We are the decree holder, your lordship. We have filed our execution, then they have,
Who are you?
Jamaluddin sole respondent who died, your lordship.
You are the legal heirs of Jamaluddin.
They are the legal heirs now of the Jamaluddin.
Yes. You want some time to,
Time for filing.
okay.
Affidavit opposition.
Heard Miss F.S. Jaman, F.N. Jaman, sorry. Heard Miss F.N. Jaman, learned counsel for the applicant. Also heard Mr. B. Hussain, learned counsel for the
This party number
opposite
one.
parties. Opposite party number
What?
1, 2, 3.
It's just number 3.
Opposite party number 1, 2, and 3. This application under order 1, rule 10, within bracket 2, read with section 151 of the Code of Civil Procedure, 1908 has been filed by the applicant seeking their impleadment in the regular second appeal number 6/2024 as respondent number 1.1 to 1.7,
1.125, your lordship.
1.1 to 1.5. Learned counsel for the opposite party has sought time for filing objection against the same. Sought 2 weeks time for filing objection against the same. The prayer is allowed. List accordingly.
It will be taken up immediately after vacation, your lordship.
2 weeks after 2 weeks it will.
If there is an IM either, 3725.
Yes,
And file this interlocutory application for striking out of the names of the respondent, proforma respondent number 5 by this appeal.
why? You are plaintiff. You are appellant.
Well.
Why have you filed?
My name,
What is this appeal?
appeal my lord against the judgment and order passed by learned appellate.
Who was this number 5 in the
Dhanuka,
before the first appellate court and before the trial court?
Dhanuka, Timothy Dhanuka.
Hmm.
He did not file any written statement, mother, he did not contest the suit. In the trial court, I mean, the first appellate.
Okay, okay. And you have any objection? Mr. J.U. Laskar, T.U. Laskar, learned counsel for the applicant / appellant, also heard Miss M. Roy, learned counsel appearing for respondent number 124. This application under order 1, rule 10 within bracket 2 of the Code of Civil Procedure, 1908 has been filed by the applicant praying for striking out the names of pro forma respondent number 5, namely Srimati Danduka Kolita from the memo of appeal. It is submitted by learned counsel for the applicant that the said respondent number 5 have not contested the suit before the trial court, neither she contested the first appeal before the first appellate court, and her presence may not be necessary for adjudication of the regular second appeal number 116/2021. Stop. Learned counsel for respondent number 124 has not raised any objection to the prayer made by the applicant. Stop. Considering the averments made in the application as well as submissions made by learned counsel for both the sides, the prayer is allowed. The name of Danduka Kalita may be strike out from the memo of appeal. The registry to do the same and list the memo of appeal, list the connected appeal again in the first week of January.
Like,
May it please your lordship. This IA is for condoning the delay of 52 days in filing the connected second appeal.
Okay, we are issuing notice. Heard Miss
P. Devi.
D. Devi, learned counsel for the applicant. This interlocutory application has been filed under Section 5 of the Limitation Act 1963, praying for condoning the delay of 52 days in filing the connected second appeal, issue notice to the opposite party. The applicant shall take steps for issuance of notice upon the opposite parties by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 30th of January 2023, list accordingly.
Wait, please, Your Lordship. Your Lordship, I'm the defendant in the original title shoot, Lordship. The title shoot was issued in favor of the plaintiff, Lordship. Where the defendant, Lordship, we have challenged that shoot, Lordship. Our title appeal was dismissed, Lordship. On the ground of,
You were defendant,
yes, Lord,
your defendant, suit was decreed,
decreed in favor of the plaintiff. Lord.
then you preferred an appeal.
Appeal, Lord.
Appeal was dismissed.
Dismiss on the,
So-
along with title shoot, Lordship, we file title appeal, Lordship, we have filed a condemnation petition. Our title appeal was dismissed on the ground of condemnation of delay, Lordship.
Delay was not condoned.
Reason although we have stated, Lordship, that was not condemned, Lordship. Though we raise, filed this RSA, Lordship, which is a substantial question of law, Lordship.
What is the substantial question
Lordship,
here?
that three on page 2, Lordship will find.
Page?
Page 2 in this RSA, Lordship, 46, Lordship.
Just a minute. Page 2 is the cost title only in RSA. Pagination is not correct. Page 2 is, which page should I go?
May I check the record, Lordship?
Page 1, 2, there are many parties.
Yes,
So
Lord.
till page 3, there is citation of parties only. Page 4, where is the substantial question of law?
May I read from my petition, Lordship?
Yes,
First one is that whether the learned court below was justified in holding that the appellant, the present appellant has no right, title, interest over the land described in Schedule B. And secondly is the whether the.
no, that question will not be decided here.
Then-
Because, let me understand, your suit was for, their suit was for declaration, recovery of khas possession. Suit was decreed. Suit was decreed. You preferred delayedly before the
Yes,
first, how much was the delay?
854 days.
That delay was not condoned. Now, this court has to see as to whether while dismissing your condonation application, any substantial question of law is involved. So right title in interest, we will not go into that. And there, that is the question of fact only.
That Lordship, whether appeal can be dismissed, Lordship, on the ground of technical ground or not first. Because it is on technical ground, it's 854 days delay, they have taken the plea for condoning the delay, they are stating that, Lordship, the decree was, which was passed, that was accordingly, Lordship, informed to, in the knowledge of this defendant, Lordship, because they have filed a CR case, Lordship, in a criminal complaint case, Lordship, that case they have served a
No,
summons.
no, what is the substantial question of law?
On the technical ground, Lordship, whether that was.
What is the technical ground? That
is,
there was
Lordship,
a delay.
yes, Lordship.
That is not a technical ground.
Because, Lordship, they has a Lordship. May I take the Lordship, the page 68, Lordship? May I read the Lordship, the order passed in this case, Lordship, in delay petition, Lordship.
Yes.
Learned advocate for both the side file Hajira seen the petition.
No, before reading the order, you have to satisfy that which point you are pressing.
Because
That this is my point and these are my submissions. Now, what is your point?
because Lordship that we have not properly informed by our council Lordship, said Lordship, we are properly represented by the council, by council submission was not recorded in the title should Lordship judgment. Lordship.
Was there any perversity in arriving at the conclusion while dismissing your
Yes. Lordship,
condonation
because-
delay
because
application?
only appearing before the court as a council Lordship without presenting the case Lordship, because there is the court title should in title should Lordship, the court has decided since 3 occasions as they failed.
No,
to-
okay, where is the substantial question of law? Section 100 says it has to be, read section 100.
Yes, Lord.
It has to be precise.
Even otherwise expressly provided in the body of this code by any other law for the timing in force, and an appeal shall lie to the High Court for every decree passed in an appeal by the court subordinate to the High Court. If the High Court is satisfied that the case involves a substantial question of law, an appeal may lies under this section from an appeal decree passed ex parte. In an appeal under this section, the memorandum of appeal shall precisely stated the substantial law question of law involved in the appeal.
Yes,
Yes, Lordship. Now,
you
Lordship,
have to precisely state the substantial question. Where have you stated? Precisely state means what? What it, you explain 100 clause 3, what it means. Section 100 clause 3.
in appeal, this section, the memorandum of appeal shall precisely stated the substantial question of law in the appeal, Lordship.
What
That-
it means.
Lordship,
Suppose you have not mentioned precisely.
Yes.
What course is open?
court even then, Lordship, may I state, Lordship? Order 41, Lordship, rule 2, Lordship.
What it says?
The ground which may be taken in appeal.
No, that is applicable to all appeals.
Yes.
First appeal, second appeal, but
Yes.
second appeal order under section 100 sub clause 3 specifically state that you have to precisely state the substantial question of law in your memo of appeal. You can do one thing. You can now state, you can take leave of this court and
Yes, sir.
submit your substantial question of law. That will be easier for us. Otherwise, taking general grounds like the grounds which you take in first appeal, in my view, would not do in a second appeal matter.
But Lordship, first appeal was not, Lordship, disposed on merit, Lordship.
Maybe, but
It is
the
no evidence has been discussed, Lordship.
first appeal was not even admissible because without condoning delay. Delay was not condoned, therefore your appeal was barred by delay.
Yes, Lordship.
So
but the
question
fact-
of discussion on merit does not arise.
Now, Lordship, the condemnation petition itself, Lordship, 854, assume that if it.
No, therefore what I suggest, you state what is the substantial question of law. Precisely you have to state. For admitting a second appeal, there is a requirement of law that the
The title, Lordship, that title, Lordship, that was not appreciated, the evidence, Lordship, we have not given that.
No, no, you are not getting it. I am still on procedure. For admitting substantial and a second appeal, substantial question of law has to be there. in the appeal. That is one requirement. Other requirement is in your memo of appeal, the substantial question of law has to be precisely mentioned. Specifically, you have to, what is the meaning of precise, dictionarical meaning? Look, use Google. To the point, precise means
To the point,
to the point.
have stated one point regarding the condemnation of debate, whether the learned court below was justified in holding the preferring.
No, they have taken many grounds.
It-
These,
One second, please.
which,
That's the notion, let me check the record. In our petition, we are there. After index, next. They have formulated three substantive questions.
which pre-substantial question of law, where?
After index space, madam, first, second. Before this lordship,
Not in the memo of appeal,
before memo.
but it has to be in the memo of appeal.
It is not part of memo.
But that is the requirement.
Because it-
We cannot devise our own procedures when CPC lays down the rules. Procedure has been laid down by the CPC. You have to follow CPC. If something is not there, then something can be devised. What is to be done?
Yeah, opportunity loss, I may allow to file an affidavit to this substantial question of in the form of that. For degrees concerned, we already executed. Now this question has to be decided first.
Okay. Decree is executed.
Whatever your point will give it to me.
No, but suppose it is found
Against,
that it was, you were not entitled, then there will be restitution. Heard Mr. B. Chaudhary, learned counsel for the appellant, also heard Mr. N. Hawk, learned counsel appearing for all the respondents.
three days.
Learned counsel for the appellant has submitted that though this appeal involves substantial question of law, however, same has not been precisely mentioned in the memo of appeal, and therefore he seeks some time to file an additional affidavit to specifically, to precisely mention the substantial question of law involved in this appeal. The prayer is allowed. Let this matter be listed again after puja vacation.
You
Uh, Again, after 4 weeks.
I do. The sort of melody is in my this second appeal, but the substantial question of law, Manoj, I have filed by way of an additional activity. I believe, Manoj, there is a circular of sport, Manoj, which requires that it should be in the memo of appeal, not in the
No, CPC says
Yes.
that it's,
100 subsection 3 also.
Huh?
In the circular also.
it has to be in the memo of appeal.
Yes, that has to be. So, Manoj, I pray for liberty to amend and bring the substantial questions of law on record, because though they are already on record by way of the additional affidavit, they have to be incorporated, Manoj, into my memo.
Okay. Third, Mr. Gang, A. Ganguly, counsel for the appellant, who submits that though this instant appeal involves substantial question of law, however, same was not precisely mentioned in the memo of appeal. Hence, he prays for filing an amendment application to bring the
I pray for filing the amended memo itself.
amended memo of appeal to bring on record the substantial question of law involved in this appeal, precisely in the memo of appeal. If prayer is allowed, let this matter be listed after 4 weeks.
Can I people date?
See, no date, no date. This is a motion, fresh matter.
Yes,
It will otherwise come.
I'm like.
May I please, Your Lordship? The second appeal is, my lord, against the charges dated 7/9/2024 and decree dated 13/9/2024, passed by the Civil Judge Senior Division, Lakhimpur, entitled appeal number 1 and 2022. I am the plaintiff, my lord, in this suit, and my suit has been, my lord, dismissed. Against that, I have filed title appeal, my lord.
Appellate court has affirmed.
Yes, my appellate court has affirmed, my lord. But my lord, there is a contradiction in the deciding the, my lord, issues by both the courts below. My substantial questions of lordship will be find at page number 12, B and C. Page 12, my lord, B and C.
Page 12B.
And C.
Whether finding of law. Read B.
Whether the findings of the learned courts below as regards the identity of the Suitland is perverse in as much as the BWs in their cross-examination admitted inclusion of the Suitland in their position while demarcating the Suitland by the concerned Mondal. My
No,
lord,
what you want to say?
my lord, I want to say that, my lord, the courts below, my lord, while, my lord, the facts, my lord, I will place in, my lord. The facts that, my lord, the plaintiffs, my lord, claiming the ownerships which they have got by way of, my lord, inheritance, my lord. And the plaintiffs, my lord, enforce my land, and that's why, my lord, I have filed this suit for right and interest, my lord, and for recovery of possessions on a part of the suit land.
Okay.
And my lord, the defendants claim that they have purchased a different plot of land, my lord, and that they are possessing the land. But while deciding that issue, my lord, the learned trial court held that regarding the identity of the suit land, the plaintiff failed to prove that right. Whereas, my lord, in the cross-examination of the BWs, they have admitted
Defendant
that,
themselves said that they are possessing a different plot.
no, my lord. In the cross-examinations, they admitted that while Lat Mondal has, my lord, demarcated the land, their land is included in the suit land, my lord. That
Okay.
is, my
They are
lord,
possessing the suitland itself.
exactly, my lord. This is the, my lord, DW, my lord, clearly in their
So
cross-examination.
perversity.
Yes, my lord.
Next,
Next, my lord, whether the learned court below committed illegality in rejecting the claim of right title interest of the appellant plaintiffs over Schedule 1 in bracket Roman 1 and Schedule 1 in bracket Roman 2 land, while declaring right title interest of the appellant plaintiffs over Schedule 1 land, without considering that the Schedule 1 within bracket 1 and Schedule 1 within bracket Roman 2 are part of the Schedule 1 land. The courts below held that I have the right title interest over Schedule 1 land, whereas declined my right title interest over Schedule 1 within bracket Roman 1 and 1 within bracket Roman 2. But that Roman 1, Roman 2 suit land is a part of the 1 suit land. It is clearly reflected in my plaint itself.
okay. The part of this,
The part of the, my lord, Schedule 1 first, my lord, I have made in the plaint,
whether evidence is there to that effect.
because the plaint itself it is clear.
So here again, question of perversity is there.
Yes, my
Heard Mr. R. Sharma, learned counsel for the appellant. This regular second appeal under section 100 of the Code of Civil Procedure 1908 has been filed by the appellants, impugning the judgment and order dated 19/9/2022 and 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 19/9/20 order dated. No, sorry, including the judgment dated 7/9/2024 and decree dated 13/9/2024. Passed by the Court of Learned Civil Judge within bracket Senior Division Lakhimpur, North Lakhimpur, in title appeal number 1/2022, whereby the appeal filed by the present appellant was dismissed and the judgment dated 20/1/2022 and 21/1/2020 and decree dated 21/1/2022 passed by the Court of Learned Munsif number 1, Lakhimpur in title suit number 30/2021 was affirmed. After considering the materials available on record and hearing the learned counsel for the appellant. How many appellants are there? Only one. Appellant. Appellants.
Appellants are 7.
Appellants, following substantial question of law are formulated in this appeal. Number 1, whether the finding of the first appellate court as well as the trial court as regards the identity of the suit land is perverse in as much as the defense, the witnesses for the defendant, in their cross-examination, have admitted the fact that the land possessed by them is included in the suit land. What is this at the time of demarcating?
My lord, that was prior to the, my lord, institution of the suit, my lord. The Mondal
Included in the suit land. Stop. Question mark. Number 2. Whether the finding of the first appellate court as well as the trial court in rejecting the claim of the present appellant is present appellant over schedule 1 within bracket Roman 1 small Roman 1 and schedule 1 within bracket small Roman 2 land while declaring his right, your right title and interest was declared.
yes. My right title interest has been declared.
Where is the
That
while declaring his right title and interest over schedule 1 land is perverse to the effect that, to the extent that schedule 1 within bracket 1 land and schedule 1 within bracket 2 Roman 2 land are part of schedule 1 land. Yes, you
Case
show
48, my lord. Plaintiff's witness clearly proved the right title interest of plaintiff in respect of the land covered by periodic patta number 19, covered by duct number 822 and 2190. Case
The-
48, line number, my lord, 4. And before that also, my lord, case 47, last,
just a minute.
Case 47, last line, my lord. All these documents and evidence of the plaintiff goes to show that plaintiffs are owners of land covered by periodic patta number 19, duct number 822 and 2190.
Where all these documents.
Yes, page
Where,
40.
what is the schedule one land?
Yes, that lordship will find in my plane. That lordship will find page 24.
Read that
Page 24, my lord.
schedule one land.
Page 24, my lord. Next page, lordship will find page 25. That in the top.
No,
portion,
read the schedule of page 23.
Land measuring 1 biga, 2 quotas, 6 lesas out of duct number 822 and 2190 periodic pattern number 19 of ward number 2. That is reflected in the order. And the lordship will find
Substantial question of law second to পঢ়ক চোন আকৌ। Schedule one land that is land covered by periodic number, periodic patta number 19, dag number 822 and 2190 is perverse.
my lord, that is reflected in the first line, right title interest may be recorded, otherwise rejecting the, then they are after, in the second question,
পঢ়ক চোন।
second question. No, second question. Rejecting the right title interest overall.
Whether
Claim of the right title interest of the present.
claim of the কি লিখিলে? Regarding his right title and interest over regarding his right title and interest over 2-1 and 2-2. It was there. Next, লিখক, this appeal is admitted. Issue notice to the respondents. The appellant shall take steps for issuance of notice to the respondents by registered post with ID as well as by
Here, my lord, I have solved where 45, my lord, respondents, only my lord, registered post.
no registered post has to be there.
Yes, registered post,
Registered post as well as by usual mode.
45.
No, there is no way out. As well as by, because registered post can be in addition.
And
I
we
just-
only, my lord, registered.
No, not on registered post as well as by usual mode. Within 7 days from the date of this order, returnable on 7th of February. List accordingly. Yes, they let the records of first appellate court as well as trial court be called for. The registry to take steps for requisitioning the aforesaid records.
I love it.
May it please the lordship. The petitioner is in custody since 551 days. Sections imposed are under 22C, 25 and 29 of the NDPS Act.
500, what is in years and month?
Pardon?
How much in years and months?
1 year, 6 months, around 1 year, 6 months.
No, exactly.
1 year, 6 months, 2 days.
What is the contraband?
Codeine phosphate, around 11,360 bottles of codeine phosphate.
Okay, who are you?
The driver,
Driver. On what ground you are bring for bail? Prolonged
first,
incarceration.
conscious possession that
Conscious position also that you were not in
I
conscious.
have conscious possession because on that particular day, 14/6/23, while I was driving the car along with consignments, it was my duty to deliver the consignment to Agartala from West Bengal. So all the consignments, they were covered by a tarpaulin, and under that, there were all the cartons. Inside the cartons, there were some electronic items and pipes, and all the bottles were hidden under that. So it is not my duty also to see what are the contents of each and every carton. So that is the plea of
How many accused are there?
how many accused.
Accused in this case, apart from you.
4 accused. Lordship may come to the charge sheet. In charge sheet, particulars of accused persons at page 29. As your lordship got it.
Yes.
Page 29, the first accused is Vivesh Kumar. 3 vehicles were caught. So first, Vivesh Kumar is the driver of the other truck. Then second, B, your lordship will find the petitioner, Saminur Islam.
Vivesh is also driver.
He is also the driver. Vivesh is also the driver. Saminur is also the driver. Now, 11 are those who are not charge sheeted. Jyoti Paswan, who is the owner of one of the vehicle. Nazrul Islam, he is on bail. He is also an owner of the vehicle, of the present vehicle, WB 29B5386. Then Ram Auto Logistics. And there is another accused who is absconding.
So only drivers are charge sheeted.
Drivers have been charge sheeted only. And your lordship, first ground is that conscious possession. Second one, I'll come.
Who
to
was
that.
the consignee and consigner?
Lordship will find that.
Okay, you make your submissions.
Your lordship, secondly, I'll come to this violation of section 52A. It is direct violation of section 50.
What violation is there?
52A, first of all, your lordship may come to the charge sheet.
Yes.
Operative portion will be page 34. Page 34 towards the last para. During investigation, the heading starts with during
Yes.
investigation of the case. May I read that, your lordship?
Yes.
The arrested accused persons is found involved into the case on the following grounds. In course of investigation, seize the drugs, a weight, sample packed at PO, and photographs were taken at PO in the presence of witnesses. Now this, in terms of section 52A of the NDPS Act, this is not permissible. And to substantiate this thing in this point, your lordship may again come to
But
page
now Supreme Court is seized of a matter.
that has
Well,
been reserved. Yes.
The
Whether
judgment has been
sample-
reserved.
But till now,
The law is that it cannot be, sampling cannot be at the place.
till now, the law is that it has to be sampled in the presence of magistrate.
Okay.
So page 32, your lordship may come. That in the column particulars of the document cited relied upon the prosecution.
Yes.
Item number 5 in that, P5. One copy of 65B certificate. Total 28 photos taken by IO during the incident by his mobile phone. Then thereafter, notice of personal search, IO kept exhibits, case has been registered. Thereafter, item 9, D9. Bazarichera PSGV 298 dated 15/6/23. The IO took the sample and proceeded to the Honorable Court for sampling. That means the IO took the sample before and then he proceeded to the court for sampling. Sample was already taken. Then the next item, IO after sampling send the exhibit to FSL. He after sampling the matter, sampling the contraband directly sends it to the FSL. Thereafter,
Where it is sent and directly sent?
not directly, here it has been stated sampling sent to the exhibits to FSL. It was his
No, that
duty.
is that note is brief of the content.
Yes, but
in-
if your lordship goes to the seriatim, later your lordship will find down there at 11, 12, 13. One application to the Honorable CJM Karimganj for certification of photograph and photography during sampling in the presence of magistrate. That means this thing has come later. First of all, they have taken the sample, the investigating officer, and then he proceeded, which cannot be done. Then IO after sampling send the exhibits to FSL
No, suppose they have taken sample at the spot.
at this spot.
They have again taken sample before the magistrate.
Yes, yes.
Then
That is-
whether it would vitiate, if they send the sample which was taken before the magistrate for examination, not this sample which was taken at
Then
spot.
your lordship, they have to clarify whether the samples drawn on the spot that was sent to FSL and that has been tested, or whether the sampling which was done before the magistrate that has been sent for FSL. So that is not clear. And that earlier portion that at page 34 during investigation, that is also clear. In course of investigation, seize the drugs weight sample packed at PU and photographs were taken.
No, but that has to be done in the course of investigation only. Sampling has to be done even if it is before the magistrate. That is also during the course of investigation
That is
only.
during investigation. But prior to that, they their duty is to search and
Your
seize.
only this material which maybe what you are submitting is that in page 34, it is categorically mentioned that sample packed at PPO.
Sample, yes,
Packed
packed
at
at the
the-
PO, yes. Mainly I'm on that. That couldn't have been, and the also the photographs, that also couldn't have been done at the PO. That stage comes later. Now.
Before
may I
the
read-
magistrate.
May I read 52A?
Okay, assuming that there is a violation of 52A. Will you get benefit in bail?
If your lordship assumes that I get conviction, then at this stage also I can be granted bail. Because if there is direct violation of the statutory provisions, their duty, the duty of the prosecution is also to see that I get all the safeguards, because it is a stringent law. Apparently, from the prime facie.
No,
it
but
appears-
here it also appears that the sampling was done before magistrate also.
Yes, maybe after that it was done before the magistrate. But once the search and once the seized materials that have been broken and samples have been taken.
How
so
it-
the sanctity of that.
No, how it will prejudice you? Suppose
there
24
might
gram
have been
samples, 3 samples were taken. How it will prejudice you?
Something can be mixed also. We
Okay.
don't. Or water can be inserted in place of protein phosphate.
Protein phosphate was in bottles.
It was inside bottles. There were around 11,360 bottles.
It was a huge quantity.
It was a
So in such a huge quantity, whether everything has to be taken to magistrate.
as per that sampling rules, they've stated that as per the sampling rules, that for every 40 batches, 10 samples has to be taken. May I see that sampling? I'll clarify it.
You have to make batches of 10. 10.
Batches of 10. yes.
10.
So out of that 10, one sample. So
Okay. What else is your submission?
And thirdly, this incarceration, that
What is the stage of trial?
your lordship, it has been fixed for consideration of charge.
Charges are yet to be framed.
Yes, yes, is yet to be framed.
When the charge sheet was laid,
It was laid on 30/11/23. Thereafter, it was fixed for consideration of charge on 1/10/2024.
now who are facing trial? Only 3 accused
Only 2 accused are facing trial.
out
Devesh
of
Kumar,
3 charge sheeted.
Out of 3 charge sheet.
Yes, Mr.
Before coming to the part, my lord, they give a look to the FIR, my lord.
FIR at page?
Page 14 of the petition, my lord. Going to on the relevant part, my lord. It's my lord, the paragraph, my lord, 3, my lord. My lord, from 2, my lord.
Page 14.
14, paragraph 2. During conducting NACA seeking duty at about 5:20 PM, 2 numbers of goods carrier trucks bearing registration number WB 11B 4702, WB 29B 5386, and also another container body truck registration number NL 01F 300 coming together from Guwahati towards Tripura. So now, my lord, in our case, my lord, here it is that is the WB in this case, who is the driver of this truck.
Which truck?
My lord, WB, my lord, to 29B 5386. That is now, my lord, in paragraph 4, my lord.
Yes.
The vehicle along with the driver was cordoned by the NACA team, and after that, I along with another 2 staff from the NACA team went to seek the another truck number bearing registration number WB 29B 5386. It was noticed that the second truck also loaded with illegal cough syrups, and when we are trying to say third truck, we are not coming to the third truck. Now it is the second truck where he is the my lord driver. Now, my lord, may kindly see the my lord, that is the page 15, my lord. Page 15 from my lord below, there is number 2, scissor list B, number 2, my lord. 71 numbers of cartons containing 11,360 numbers of bottles of protein phosphate and chlorophenol malate syrup, escap cough syrup, each bottle containing 100 ml quantity belonging to batch number so and so, so and so, so and so. This is in our part, from our part, my lord, present examination part. Now, my lord, may kindly give a look to page 17, my lord.
Yes.
Page 17, my lord, name and address of the accused person. I am in the number 3, my lord. Saminur Islam, driver of the WB 29B 5386. Now, my lord, from the FIR itself, my lord, is from the very much of the conscious position. That is from the person he is in the
No, no. Suppose the owner engages a driver, truck driver.
my lord.
Whether driver is supposed to know what he is carrying in a goods vehicle when the materials are inside the carton.
My lord, in the both way, if my lord, that is applicable in the both way. In my lord, it may be like this also, my lord. That is the owner has given something.
Suppose
And it is the truck driver who has taken it.
maybe.
He may be.
No,
My lord,
just
both
I-
way it is applicable.
I just want to. There is a train. There is a local pilot, train driver.
My lord,
In that train, you are carrying a carton.
yes, my
The at the time of
My lord.
search, the person carrying the carton
My
fled away.
My lord.
You apprehend the driver
my lord.
that
My-
it is
my
in
lord.
it.
Case of train, my lord, the proper mechanism is there. Who will, my lord, and these are private vehicles, my lord. The truck,
So they have to show
my lord.
that he was not involved in the process of what is
Yes,
uploading.
my lord. Trial, my lord, it will come to light whether his
Mm,
involvement is
no,
there
no.
or not. That part, my
Even
lord.
during bail application stage of bail, if they can show that he was not in the process of uploading, loading of the on the goods in the truck, and his only duty was to drive the vehicle, then perhaps he may be having a case. Otherwise, because here you have not you have not made accused the consigner.
I'm coming to that part. So only just my lord, now the FIR, my lord.
Okay.
Now I am coming to the my lord search sheet. So my lord, here, my lord, that is the search sheet dated my lord 13/11/2023, my lord. And there are 13 numbers of PWs where my lord, both the driver, my lord, they are my lord search sheeted and another person's who are not search sheeted. Only 2 numbers of my lord person was searched. Subsequently, my lord, that is my lord on my lord 10/5/2024. My lord, that order my lord flag mark. Supplementary CD along with the final form submitted. Along with that search sheet, my lord, 13/11/2023, my lord, supplementary search sheet they have provided. And because of that, my lord, another accused person who was earlier not search sheeted, my lord. Now, my lord, presently the trial is going on, my lord. And there are 3 numbers of accused persons.
Your lordship was pleased to grant bail in that matter. There what had happened, this supplementary charge sheet which was filed, that was filed without taking the leave of the court. On the date when that person was arrested, that is owner of this present vehicle, Nasrul Islam.
On some other ground he
On
was.
some merit,
Some
your
other
lordship.
ground, he was not present there.
No, but the charge sheet has been laid against the driver only. The third one,
First
was not
first
charged.
search sheet, my lord, against 2 persons.
and
Present
third one
petitioner
is,
And another was the Vikas Kumar, my lord.
who is Vikas Kumar? He is also a driver.
He is another first
Okay.
one, my lord.
So
where
only
contraventions were recovered,
drivers have been charge sheeted.
my lord. And my lord, in the next part, my lord, when they filed that supplementary search sheet, that part is different, my lord. That was my lord filed, and because of that, my lord, on 5/2/2024, my lord, accused Nazrul Islam was arrested, and 10/5/2024 supplementary search sheet was my lord filed. My lord. Then thereafter, my lord, 26/2022, my lord, copies,
Now, suppose you arrest a person
my lord,
and you say that I am continuing my investigation.
Right.
And you file supplementary charge sheet after 4 years. Whether the earlier arrested person would suffer for that.
my lord, here not my lord, because earlier, my lord, 13/11 it was submitted, and now, my lord, the person was arrested on 5/2/24 and 10/5/2024.
Your lordship, he was arrested on 3/2/24. On that day, there was no incriminating material against that Mr. Nazrul Islam. Only on 5/2, when he went to take Zimma of the vehicle, he was arrested. The investigating officer on that day did not take the leave of the court for further investigation. So on that particular ground, your lordship has granted bail. Operative part, your lordship will find at page 45 of that order. There are 26.
Which, you are resident of which place?
And of Karimganj.
Both the drivers?
Regarding.
No, you are praying for bail of only one.
Only one.
He is the resident of Karimganj. Yes, Mr. Bushra.
Now, my lord, then on 26/2024, that was fixed for my lord copies, and on that day, my lord, Wakalatnama also filed by the present accused. 26/2024.
Your lordship, I'd like to intervene. I'm from West Bengal.
My lord, then 12/8/2024, my lord, copies were furnished. 12/8/2020, copies furnished. Then, my lord, it was,
After 2 months.
my lord, yes, to 26, then, my lord, 12/8, the copies were furnished.
Okay.
Copies were furnished on 12/8, my lord. After 12/8, my lord, it was fixed for hearing on search. Now a discharge petition is pending. That was heard, my lord. And as per the record, my lord, that was the fixed on 5/2/2024. The discharge petition is filed by the present petitioner, my lord. That was already being heard. And my lord, as because the record is available up to 5/2/2024, So my lord, on the basis of the e-code system, I tried to find it out where I found my lord, what is found in the my lord e-code system. That is my lord 4/12/2024. Learned trial court judge on leave, my lord. So next date fixed on 17/12/2024.
Or copies.
No, my lord, for regarding the, that is the order regarding the discharge, my lord. Discharge petition they have filed, the hearing completed, my lord. And that is pending.
Regarding the discharge petition.
My lord, that I have flag mark, my lord. I have flag marks in the record, my lord. That was my lord file. My lord, that is, my lord, that is my lord, here, my lord, this is my lord, status of the case, my lord. Till today, because here only the thing is that, my lord, that is a record available up to 5/2/2024, my lord. That is or that is available. But the rest part, what happened on my lord, sorry, my lord, not 5/2, then 4/12/2024, that order was not there, my lord. So I have done so the e-code system where I found only that part, not the order. Now, my lord, here, my lord, regarding the prolonged incarceration, my lord, that is the 548, maybe 531, my lord, about 1 year, 6 months, my lord. But my lord, here as because the search sheet, my lord, submitted, the complete search sheet submitted on my lord, that is the 10/5/2024, my lord. 10/5/2024, my lord.
But you have not submitted charge sheet against any one offense, against the arrested accused only.
Against the arrested accused and my lord, because they were not search sheeted. Then thereafter, Mr. Nozirul, my lord, another one that is who is the my lord, owner of the truck. My lord. Against him, there is supplementary search sheet was filed, my lord. And as a result, my lord, trial against 3 persons. My lord, may kindly see, my lord, 3 persons, 3 accused, my lord, facing the trial, my lord. 2 are the drivers, another one is the owner of the truck.
Okay. So this is not, according to you, a case of prolonged incarceration.
My lord, it's not a my lord, and even my lord, now that they have filed the discharge petition, my lord, that is pending, my lord. That's completed, my lord, so waiting for the outcome, my lord. Outcome of that. And my lord, we have to now the PWC will be examined, then thereafter, my lord.
Another 4 years.
No.
And my lord, there are, my
And
lord,
what is your submission regarding their, what is the response there regarding their submission that the petitioner was not in conscious possession, the contraband was in the carton and it was covered with tarpaulin, and he was only performing his duty to carry the truck from one place to another without knowing what is there in the.
my lord, in this regard, my lord, because my lord, he is found in the truck, my lord. And my lord, another person regarding, these 3 trucks are together, my lord. And another, the 3rd truck, my lord, when my lord, may kindly see that truck, the driver, he fled away, my lord. All 3 trucks are together, my lord. Only they are able to make these persons, my lord,
Okay.
truck. But the 3rd person from the NL truck, they left away, my lord. He fled away, my lord.
That means he may be knowing. The person who fled away, he was knowing.
Maybe, my lord, that is the situation, my lord.
And they may not be knowing.
They may not get opportunity, my lord.
That is one way of
Also, my
looking
lord,
at it.
but both the way, my lord. So, my lord, my only humble submission before your lordship is that, my lord, not at this stage, my lord, at
No,
this moment,
actually-
because, my lord, and regarding, my lord, the prolonged incarceration, my lord, whenever, my lord, even Muhammad Muslim case, my lord, when it was stated, my lord, that time, my lord, is away, that it is 7 years, my lord, that time, my lord.
Yes, that means you have
And
to,
even, my lord, Muhammad Muslim, he was not with that position, ma'am. Here, my lord, the person found with the contraband, and he is the driver who is carrying the minor contrabands, ma'am. And my lord, if it is 1311, my lord, that was the my lord, the final search sheet, and no, my lord, supplementary search sheet is filed. My lord, then that is a different, my lord, stage. Here, my lord, that is because, my lord, regarding the training of SARS that will come after, my lord, this supplementary SARS.
Supplementary charge sheet has been filed in regard to Nazrul, not me. I have
No,
been
but
charged
trial could not start.
with- That is not my
Okay,
fault.
no. If you interfere, then your bail will be rejected. You will get chance to reply. Yes, Mr. Bacha, anything?
My lord, that part, on regarding, my lord, that is the, my lord, regarding that is the prolonged interpretation, my lord, that is the Article 21, my lord, additions. And my respectful submission before your lordship is there. These are the matter, my lord. Whenever we, my lord, look into that, the additions of Article 21, my lord, this is not a case where one person, my lord, that is the offense against my lord body, or something else. But at a large, my lord, because of this fancy and my lord, these things are otherwise also, my lord, affect the rights of other people also. And even, my lord, my humble submission, my lord, along with the other authorities, my lord, which is based, and it is known, my lord, even, my lord, from Muhammad Muslim's case, my lord. I have also gone through that, my lord. My lord, even, my lord, in our, my lord, rebel court also, my lord, in some other cases, the court just mentioned, they even, my lord, on this regard, my lord, regarding that period, my lord, in some cases, they also, my lord, got granted my bail, my lord. If, my lord, allow, I may,
No, that means court has to come to a finding
my lord.
whether, how much period it consider as prolonged incarceration.
Yes, my lord. And here, my lord, the case is that.
And there cannot be any fixed
My lord,
norm.
my lord, my lord. My lord, that is my respectful submission, my lord. Here, my lord, the case is that, my lord, the 13/11/2023 search sheet, my lord, filed with admitted position. And, my lord, 13 numbers of PWs are there. My lord, in that particular search sheet, it is clearly stated they're not search sheeted. Amongst the not search sheeted person, one person who is now facing the trial, my lord, the outcome will be different. He may be acquitted.
Now, why he was not charge sheeted?
That time they are not getting something sufficient materials.
What he got?
My lord, after that, my lord, they get some, my lord, that is, my lord, the 164 statements they have taken from some persons, my lord, who, my lord, make some statements.
Fake statement.
Maybe, my lord, that I don't know, my lord.
I remember that he heard somewhere that he is involved in transporting drugs.
But, my lord, the trial start after, my lord, this. Now 3 persons are facing trial. That is the
So-
admitted position. And discharge petition is pending, my lord. Present accused petitioner, he has also filed the discharge petition, like. He was heard by the learned trial court, my lord.
Okay. Anything else?
That is my respectful submission.
Yes, Mr. Dutta, you want to say anything?
Charge sheet again, the consigner in the seizure list defined. At page 20, item number 5, one tax invoice by invoice dated so and so. Sender of the invoice is Debranjan Das. He is the consigner from Santipur. West Bengal.
Where?
Page 20, seizure list.
Hmm.
Item 5 towards the end. One tax. Debranjan Das, he is from West Bengal. So he was the consignor in regard to this vehicle. And the next item, 5 only, receiver of invoice is Samir Saha, Hawker's Career, Agartala.
Because codeine is a medicine also, cough syrup is a medicine also. There would be normal flow of transportation of this medicine also with valid documents. When it becomes an offense under NDPS Act, if they are unable to show any valid documents,
License. Mr. Debranjan Das is the consignor and Samir Saha is the consignor. So on that particular day, I was going to Agartala to deliver those consignments. makes it clear here.
What was the finding against these two?
Against these two persons,
Why Debranjan Das and Samir Saha were not implicated?
they were never called up for investigation.
Okay. How many bottles were there?
11,360. This particular rate.
Nineteen.
11,000.
Okay, heard Mr. S. Datta, learned counsel for the petitioner, also heard Mr. K. K. Basha. K. Basha, learned additional public prosecutor. Let this case be listed for delivery of orders on 19/12/2000.
Okay.
Finish.